Hello everyone and welcome back to another live trial day with me, Grizzly. This is Grizzly True Crime. If you are brand new to the channel, I am South African, I live in Switzerland, and I love watching trials with you. Thank you so much for being here. Jinxie, it's so nice to see you. I haven't seen you in a while. Oh my goodness, thank you for your $20 sticker. That is so amazing. And I was just lurking while putting on my lipstick. Everyone always emails me and asks what shade of lipstick I wear. You can check it out in, I don't have one to show you here now. I'll show you quickly. It's not sponsored. It's just a regular question. This is what it looks like. That's what it is. While I was putting that on, okay, mods, if you could share the lipstick I wear. Nightbot will help us. I was lurking a little bit and I'm like, whoa, the day started off with drama already. So I'm very excited for this day. Let's see what's going to happen. I did have a poll asking if you think that Donna Adelson will take the stand, and about 59% of people think she will. I agree with that 59%. I think she will. Huh? So let's bring up the court feed and let's start this day, shall we? Let's just go forward. Okay, here, they're going to come here, yeah?
I'm not.
It just started suddenly, just like this.
I'm not accusing the state attorney's office of doing anything. I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in under Sheriff Google. However, at this point in time, this does not invoke court to need to go through a Richardson inquiry. The witnesses that you're referring to, have they been disclosed to the state?
Apparently, the defense, we're going to hear more now, but apparently they went to the jail. I'm understanding where Donna was incarcerated and they wanted to speak to someone there and the person didn't want to speak to them. So now the defense is throwing a little bit of a tantrum, even though they never planned to speak to that person and that person's not subpoenaed. They're like, what if they know something that we want to know? We want to know, okay? Khalid, thank you so much from South Africa for your sticker.
It's not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers. If you are not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the under sheriff, I will. But as far as perfecting any subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules...
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdiction.
This sounds so... I don't know what other word to use. I'm not trying to be rude, but amateur. Judge, this person, we don't know that they don't want to speak to us. We don't even know who they are. Wait, we heard that they don't want to speak to us. So now we want to know what they know so that we can decide if we want to maybe use that in our defense. What? No, leave that person alone.
Additional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you, Your Honor.
Okay, so Bring in the sheriff so we can hear what happened.
Judge, if I may. Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of trial. But that part of it, again, these are certain things I cannot assist with. And the Sheriff Google, please raise your right hand, sir. Do you swear?
Sheriff Google. Is that you, Uncle Google? Oh. Can Sheriff Google please raise your hand and tell us everything? What did you find? I think his name is literally Sheriff Google, okay?
Or affirm the testimony you're about to give to be the truth.
Yes, sir, I did.
If you can just stand in front of the court reporter instead of taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Addison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with general counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
Any examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
Sheriff Google, there is no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
It's quite something, hey? What a start to
Concerning
the
the other witness, who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor. Judge, the information that we provided to Your Honor was purely to put it on the record that we had followed that information. After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
Right. As to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as a part of your case?
There you are.
As to the guard, if you need to follow up with a subpoena for this individual, as they have chosen not to speak with you, you need to do so with all haste. The jurors at the time of selection were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
Longer.
And I apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call Kristin Adamson, Linda Bailey, Sarah Newhouse, and Marissel Descalzo.
For this afternoon.
This afternoon is up in the air, and that's going to require some additional conversations with our client.
During the lunch break, that will be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it will be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
Oh my.
Please bring in the jurors.
So about 4 witnesses
Your Honor,
this
I
morning.
know that 3 of the witnesses
4 witnesses this morning. It sounds like lunch break, and then it sounds like Donna is on the fence, eh? About whether she's going to testify or not. The way that the judge words it is like, well, she's going to have to make up her mind during the lunch break today, while she's looking for her scrunchie, okay, if she's going to testify or not. I mean, her hair looks extra clean today. She's looking like she put maximum effort into her appearance today, and I think that means she's going to take the stand. Take the stand, Donna. Come on, tell us. You know, we know you practiced at the pretrial hearing, okay? We want to see. My goodness, wouldn't advise, but we want to see.
are here. Ms. Descalzo's flight does not arrive until a little after
10 o'clock, you said.
Yes, sir.
SJLD Film says, up in the air.
Oh, Ms. Kaplan,
I know, right?
Neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
Yes, sir. I'm good. Thank you.
Okay. Interesting to watch all of the action here. Let's go forward a bit there. Ooh, Donna's looking nervous today, don't you think?
Good morning, members of the jury. Good morning. Everyone can be seated. We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor. The defense will call Kristin Adamson.
I am not guilty of typing noises. But I was typing, but I muted my mic, okay? Okay? Myself and the court reporter were just in sync over there. Thank you so much, Vicky Russ, for your $10 sticker. You said, thank you for all you do. Love the snark. Thank you so much.
Please raise your right hand. Good morning. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You may take your seat.
Thank you.
You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristin Adamson.
Okay, Ms. Adelson, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law, and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay. Are you board certified?
Yes, I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again where I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the Executive Council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
In your work as a family law attorney, did you have occasion to represent Wendi Adelson?
I did represent Wendi Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because, unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that, and that going to court always is a little bit harder. But in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of.
Run-of-the-mill? Ma'am, Wendi was fighting over tennis rackets. This is at the center of the case. It was a very bitter divorce. Said every friend and family member that knew Wendi and Dan. Like, what do you mean? Somebody said, wait, where is it now? Donna said, did he have her spell her name? No. That's why I was quickly looking at the defense witness list, the potential witness list, like, wait. So we could spell it correctly, as best we can, okay? Wow, okay, so, yeah, someone says, are they setting up part of Wendi's defense? Is that what's going on here? Interesting. Well, I mean, I don't believe this.
Case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, they're not here in front of this court, so they're actually, one of them settled. But one of them, mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And another one that I have right now is a person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to being close to my parents. It's a very common thing for people to want to move to be near their parents. No matter.
Sure, but what's not common is what the defendant is accused of doing in this case based on the relocation being denied. Okay then.
How old they are.
Now, do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do. I usually let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood. Now, you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot at best. Sometimes.
Bring in the behavior panel. Analyze this, please. She seems actually uncomfortable talking about all this, even though she's spilling lots of tea, looking up the whole time and just like, are we done yet? Are we done yet? Okay. We're just going to minimize this divorce. It was nothing. It wasn't bitter at all. Okay, moving on.
A little bit more, sometimes less.
Okay. Did you have that conversation with Wendi Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did. Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relook it afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
So in other words, is it not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Okay. Now, the standard for a modification, what is that?
Standard for a modification is a substantial change in circumstance. And at the time that I had Wendi's case, there was also another component which no longer exists. But at the time that I had Wendi's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. That detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
That's why the motion to relocate was denied. Zenchen Art said, Grizzly to crime, from my experience, this is how relocation cases go in general. I know. You said 20 plus years family law experience. I get it. But this was not in this case. This case is the exception, not the rule. That's why we're here, right? fifth person that could be convicted. So, well, I mean, the jury saw the emails as well, you know, with Donna's emails, so we know how enmeshed she really was in her daughter's life, right? And this definitely, it would be hard to argue that this wasn't a contentious divorce, right? And many divorces can be contentious and don't end up with hitmen being involved or end up in murder, but many do as well that we look at in true crime, right? So I hope I'm making sense. Brown-eyed girl said this has been great for weeding out incompetent attorneys. I can't believe she's being allowed to spill all this. Yeah, I don't know. Thank you for being a member for 25 months. I really appreciate it.
That's why you advised Miss Wendi Adelson if she wanted to try relocation, she should do it at the front end.
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school, children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
Okay. Have you ever been successful in convincing a judge to grant relocation?
I personally have only won one case in 37 years for relocation.
So, would you say it's difficult?
I think it's difficult.
Now, even though you've only gotten court approval for one with the client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister. She moved to Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And I think you said you explained all of this to Wendi.
I did.
Was she aware that the chances of success were low?
Yes, I mean, I told her that this was her shot. I thought she had some good reasons. I would never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it for many reasons, but including the fact that her parents were down there, that Professor Markel had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about the family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit.
To kind of pause right there. Dr. Patrice Berry's in chat. Thank you so much for being here. You said, so did they work on a different plan? This could backfire on the defense. I can't wait for cross-examination. If you guys haven't checked out Dr. Patrice Berry's channel, do check it out.
Reports, I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
And when completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, Did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns. So you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on the financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits. And I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital, or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow, so you're entitled to the growth on it too as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court at least.
Now, I want to back up a little bit. What happened with Wendi Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendi Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to move, but she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
Oh my word! And now, actually, defense. Please tie this back into your client. Do tell, because it just sounds like we're going back to 2012 when Wendi filed for divorce. Right? Now let's bring it back to Donna. Bring up the emails. Now, Mary has a question. I'm going to read this first because I think this is the answer. Then, Mary, I'll put your sticker on the screen. Thank you for your sticker. So, Edwin Edwina Caparelli said, I think because this case is dissolved and because of the death of the other party, she's allowed to speak about this, especially because it pertains to a crime. Could be. Let us know if you have legal experience in the chat. Always appreciate that. Mary said, what about attorney-client privileges? I don't understand how she's testifying about Wendy's private conversations with her attorney. So I think what I just read before was the answer. Thank you, Mary, for your sticker.
During that hearing, or after the judge made those comments, did Wendi go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendi about that, and then Wendy's parents were there, and I actually spoke to Wendi and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendi ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point...
Okay, and again, is this Wendi on trial? No. Can we get back to Donna? Right? Zengen Art said, I'm guessing Wendi signed a waiver. Otherwise, generally, privilege is to communication with a client when no other person is present. Most of this is public record.
Time, I believe it was approximately the third week of June of 2013?
Yes.
Okay. And what was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to be. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendi Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past,
Now,
and since that time as well.
Subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did. And at that mediation, we came very close to settling it, and we were there for quite a long period of time. But we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
And before, we had a court hearing trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was the, if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion, and then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose, like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
Oh my. Okay, Grandma Pumpkin said, Gisela, can Mr. Grizzly make 6.2K coffees, please? 6.3 now. Should I get him to come home from work? Come here and make 6,347 coffees. I think we need it at this point. I do have my coffee. I was actually wondering if someone's going to ask. Yesterday when we finished day 7, I had a double coffee made, but I didn't get to have it because then the judge just said, okay, we're done for the day. Which, that was interesting, wasn't it? They ended really early yesterday, and I was thinking, is that so that Donna can rest so that she could take the stand? Or what? But now is this like stalling? Donna, just take the stand. We know you want to. Also, I had that coffee this morning, and I was super awake at 5:30 and asking Mr. Grizzly if he wants to go for a run. You want to go for a run? And he's not a morning person. He's like, no. Yes, let's go now. He did eventually go for that run. And I did debrief him about day 7 of the trial. He needed to know everything.
Our purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore, and Professor Markel is not with us anymore. So a lot of people in that mediation are gone, and Ms. Adelson has waived confidentiality.
Okay, so there it is. That's what you said earlier, Zen Jen. C. Taylor said, what about the Markel family heirloom jewelry? Did your client return? I want to know that too. Did your client return that to the Markels? Probably not, right? Probably not. Oh, man.
You beat me to the punch, Ms. Edison. With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all subjects as well. You may continue.
Thank you very much, Your Honor. Ms. Adamson, can you tell us that Charles Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last-minute little dust-up during the mediation. So what we did was we called the Charles Schwab account representative. And during...
Ma'am, is that where Wendi was trying to steal $500,000 from Dan that he found out about? And the filings got even more voluminous? Is that what they're talking about? Now, David Johnston, that's right. You are correct. You only get a coffee if you hit the like button. Yeah? Or if you checked if your like button worked today. Does it work? Just tap it once.
And this is not uncommon in mediation. And I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined, in his opinion, what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple accounts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in... Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement. And Professor Markel had almost $500,000 worth of non-marital Charles Schwab accounts of his own. So he had non-marital.
Ma'am, actually, defense, we need visuals, okay? I have not been formally diagnosed, but I think I speak for the community when many of us are visual learners and we might have ADD. Please, our brains are checking out. What is this about? Put Donna on the stand.
Money as well.
So based on what you've discussed, Mr. Markel was aware of the non-marital status of that portion of Wendi Adelson's portion of what she would get.
He was.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
Shortly after the divorce was final, did Wendi invite you to get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendi Gets Her Groove Back, and I had several friends I knew of Wendy's that were there as well.
Sorry, pause. So Wendi had a party that's called Wendi Gets Her Groove Back? Oh my. Okay, I think she needs a PR manager.
And it was just sort of a, Wendy's in a good place, come celebrate my new life party. Yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
And costs of?
That includes costs and everything, I think.
Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, subsequent, did the marital settlement agreement require that Mr. Markel pay Wendi and yourself certain sums?
So, according to the marital settlement agreement, Professor Markel kept the house. So he was supposed to pay Wendi for her part of the house. And all the other assets were divided equally so that he kept.
And he didn't want to initially because she had apparently stolen $500,000, if I understand that correctly. Okay, let's at least look at a picture so our brains can be reactivated. Firstly, Ms. Id, thank you for being a member for 22 months. You said, proud Grizzly here. Thanks for all you do. Thank you so much. Look, everyone. It's a close-up of Donna's scrunchie. Yeah? Tallahassee Democrat literally published that. I'm like, oh, better screenshot that. Look at it up close. That's what she has after lunch. The scrunchie.
He kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendi did, and it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendi did. So that was part of the agreement. He was supposed to pay me $10,000. He was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st?
I think that's right.
Did Mr. Markel pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendi, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markel was going to pay.
Did he pay?
He did not.
What did Wendi ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier if people will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money, and I asked for a court hearing on all of that.
We're waiting. We're summoning Georgia. That's why I put the picture up. Okay, let's manifest it together now. Georgia, please can you cross-examine now?
Okay. Sounds like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Okay. Did that prompt Mr. Markel to pay?
No, it did not.
What happened?
So then Mr. Markel hired a new lawyer. And his new lawyer filed a responsive pleading to my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first responses and motions, his first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense because if he...
Ma'am, we're at a murder trial. Dan Markel was murdered. There's already been 4 convictions. I'm talking to the witness, right? Not the sticker. Misty, I really appreciate it. I'm going to read it now. Okay, so the little bit of the sarcastic or, I guess, snarky undertone towards the victim, not a good look in my opinion. Misty said, I've seen this in other cases when the defendant has a lot of money. The attorneys will call a lot of nonsense witnesses to charge more on depots and to make it look like they are doing more work for them and charge more. Oh, interesting. Racking up them bills, right? Now wait, what did I want to say? Jen, you also said, there, wait. Oh my word, I'm trying to find the comment, sorry. You also said something similar to what I just said, that you're not liking the attitude about Dan Markel in this testimony. Me neither. This is horrible, oh my word.
He had power of attorney, he would know what the money was, so it didn't make sense to me. But anyway, that she had hidden that money and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached and he shouldn't have to pay her the money.
So he filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendi at the time, is that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on and Wendi and how I don't think at this point he alleged that, he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
you filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
In the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendi's part?
I think he filed at least 1 or 2 more pleadings that did that.
And before we get to the final one, that, you advised Ms. Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response, and I told Wendi that it wasn't, and not to worry about it.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markel and his attorney were attempting to depose Ms. Adelson.
So what happened was I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition. We went to court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing, the judge read all of the pleadings, and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate. And
On that note,
said that she was very unhappy with.
My bad, I was very naughty. I took a peek. I'm like, how long is this still gonna go on? And then I may have skipped forward like 2 or 3 minutes by mistake. Because we're about 20 minutes behind the live feed, you know. So it's still gonna go on for quite some time.
Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
with some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file an additional pleading concerning complaints that he had about right of first refusal, parenting time, and things of that nature?
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting, and it was that that Wendi wasn't allowing him to FaceTime with his children as much as he wanted to. That they weren't allowed to go to be present at the same birthday parties. That if there was a birthday party that he was at, she wouldn't come. I mean, things like that, and that. That she
A little bit, no, a lot tone deaf.
She wasn't. I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids, and I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time. He also, I think it was that pleading where he went on a little bit more about Wendi and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing, or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Okay. Now, the one motion concerning his my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals, but it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parentings. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they become completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use those terms. I've seen it.
Okay. The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No. It's not possible. And I told Wendi that.
Okay. Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings.
Donna is well pleased with her testimony. Nodding along. Yes, veneers, you'll get that. Scripts from Harvey. What? Donna, what are you offering this witness, hey? How much is she getting paid, huh? Is Harvey paying? What's going on here? And paying how much? Veneers? Scripts? Land? Trailers? A grand piano? Who knows? Tiki T.Y. said, I'm so over her. I wonder what the juries are feeling and if they are bothered by her too. So obviously, usually, we don't like to snark at witnesses, right? We don't want to do that. But the thing is, sometimes they cross a line when there's witnesses for the defense that then start victim blaming. I don't like that. I don't like the victim blaming or the tone at this point. That's getting on my nerves quite a lot, right? Okay, so anyway, we can do it. Let's listen to more.
He filed on that regard. It may have been 3. And it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
Okay. And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Okay. Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendi.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendi Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't even after the even afterwards. I didn't. They were fine. I had no issues with them. But I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Okay, just a moment, Your Honor. Nothing further this time?
Cross-examination.
Morning.
Good morning.
So you said you weren't aware of Donna.
Okay, so it's attorney Sarah Dugan that's now doing the cross-examination.
Adelson's involvement. in
She was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendi's filings and having Wendi copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings, how about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendi to put in her filings in Wendi's voice?
Not that I'm aware of.
Okay. Did Wendi, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendi on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendi sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendi.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that time.
I'm always hopeful, but
Right.
And I thought she had a good shot or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes.
Okay, even given your best guidance?
Yes.
Okay. That's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right, and at that relocation hearing were Donna and Harvey Adelson possible witnesses?
I've been trying to think about that. I think that's probably why I had them sit outside, is because
Right.
they could potentially be witnesses in invoking the rule. However, I think I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So that's right. Yeah.
Okay. So that's why they were in the hallway.
That's why
most
they were in the
likely.
hallway. Yeah.
Okay, not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. I came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
Well, I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendi was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendi Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No, okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendi, and then briefly, as far as I remember, because I mean it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, I didn't agree with the judge, but this is the judge, and they get to make the decisions. And I think that Wendi went and talked to her parents without me, and then came back and said, "Okay, we're good. We can go into court and we can stipulate."
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face.
No.
Okay. You talked about Dan Markel not paying what he was supposed to pay according to the settlement agreement. In Dan Markel's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact of that he was accusing Wendi of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markel held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforced it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue, and that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying, and then.
Could I ask you a different question?
Okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. And it would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequences, we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and we would, and then I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license, possibly? If he's held in contempt of court? Or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendi Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did. Because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendi Adelson should be held in contempt?
I don't know if contempt. I don't know if I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more Wendi should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
That she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendi or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is when he did that.
Was that personal attacks on both Wendi Adelson and you?
Correct.
And he was alleging that Wendi Adelson committed fraud, right?
Yes.
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendi Adelson's behalf, right?
Correct. That's happened before, though. I mean, I've had that happen before.
And he alleged Wendi should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markel and Wendi Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on
By gone, you mean murdered. Okay, thank you.
Wendi Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not. We've had a few people get murdered, and I've had a few suicides,
Okay.
but it's rare, and I remember all of them.
Right, but not contentious.
Sometimes I don't know with the suicides. I don't know.
That's all.
Thank you.
Right, but not contentious. Just murder involved. Not contentious. I do like Sarah Dugan's subtle snark, huh?
Redirect examination.
Briefly, Your Honor. first witness?
You may.
Ms. Adamson, I'm going to approach and show you some, I'm sorry. Ms. Adamson. States demonstrative A, I think it's Court Exhibit 1, page 441 of the demonstrative.
Shame. Here's Dan Markel's dad and mom, and they have to listen to this crap. You know, this must be really, really difficult, especially to hear the tone towards their murdered son. It's terrible.
And then I'm holding 454. If you can hold that,
Sure.
please.
Okay.
Is that the March 26, 2014 pleading that Mr. Markel filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's, time with the children? Does that reflect that Mr. Markel was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Ms. Adamson, did you testify that the divorce was not contentious, but some of his pleadings post-divorce were contentious?
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendi Adelson and yourself.
Correct.
Okay. Is that
Sir, speaking about a murder victim as he attacked you and Wendi. Hello. He was murdered. It's very tactless, huh?
what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markel not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling. To you.
As far as I know.
You don't know what she said privately, do you?
I do not.
Concerning Wendi Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you?
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendi Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendi, I don't remember that Wendi had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of chat GPT now, a lot, telling me what I should be filing.
I don't think you're...
I would like to see those chat GPT records. Like we said, Uncle Google's going to get you. Maybe, what shall we call that? Auntie ChatGPT is going to get you too. How many times is she going to mention that? Pernille is throwing tomatoes at this point. So is Joanna. This is terrible. It just is. Oh my word.
You're the only one there, ma'am. Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay.
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
Just a moment.
Hopefully not.
We'll
Did I
retain
say
her,
that
but
out
she's
loud?
free to go about her business.
Thank you.
You may step down.
Yes, please go about your business. Oh dear. You like that, Donna?
Please call your next witness.
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break. Jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hands. A very equivocal wave, but I'll take it. The bailiff will take you to the jury room. Resume at 10:05.
And we will skip over the break now. Let's just see if there's anything else. The jury needs coffee after that. They're not going to the bathroom. They're gonna get coffee, I think, huh? They're like, oh man,
You
it's
can
gonna
be
be a long day.
seated. Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. And we'll try to start again at 10:05.
Thank you, Your Honor.
Whether or not there were any, whoever's listening.
Okay, so we just teleported through that break. And let's continue. Next witness with a binder that Georgia Kappelman, the state, seemed to have really good rapport with. So that's great. Looking forward to cross-examination on that one too, right? Okay, they're coming back any second now.
For when we advised Ms. Bailey of this information.
Well, if whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Linda Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Kappelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
And I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to the witness yesterday, I gave instruction concerning that. It's concerning Ms. Bailey will review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that.
Another one. Yesterday, there was a witness. I made a YouTube short for you guys, so you can just check out those types of highlights, you know, where the defense said they were looking for the witness everywhere in the hallway, trying to text him, but he was actually sitting in the courtroom, listening to testimony. Thankfully, the testimony was not related to what he would testify to, and so the judge allowed it, but oh man. Is this potentially another case like that? Wow.
But as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
You can let the jurors know. I'm going to go to the court reporter's office to check the sidebar. From there, we will finish this matter and resume testimony.
Well, now there's quite the long break. They're going over the sidebar to see when they spoke about the witness and to see if she was in the courtroom and what she heard. Am I understanding that correctly? Wow. Okay, so who knows how long this break will be. What shall we do with ourselves? Okay, firstly, let's go forward. Okay, so the court is on a short break. My goodness, that was painful. That was a painful morning so far. So tone deaf, my goodness, the way that attorney spoke about Dan Markel. Nobody said any victim has to be perfect, you know what I mean? If somebody in chat earlier said, well, maybe he was difficult to deal with. Then he was murdered, so that changes the tone. You know what I mean? Difficult to deal with, contentious divorce is one thing. Hitmen being paid to kill him, oh yeah, that's another. My goodness. So, okay. Yeah, Crystal said, how does that happen twice? It's quite something, huh? Kerry said, I get the impression the defense is either very unprepared or very dirty, or both. They're upset they didn't get it their way regarding a last-minute witness, and now this. I mean, what the heck? Was this witness that they want to call listening online? Probably not, because then she wouldn't hear the sidebars. In the courtroom? Wait, let me also check. Linda Bailey, they said, right? I'm reading tiny writing on my phone here. Hold on. Thank you also to Grizzly Cat for finding all these great pictures. You know, such a nice picture of Dan Markel up there. She finds great pictures and edits them, so that's a great one as well. Diane, welcome. Thank you so much. I just quickly want to see if I could see. Yeah, Linda Bailey, lawyer. It's a lawyer. Esquire, a Tallahassee lawyer. Okay. So the defense is apparently having about 4 witnesses today. And then they will take an extended lunch, said the judge. Instead of an hour 15, they'll take an hour and a half. And during that time, especially the extra 15 minutes, Donna will have to decide if she's going to testify or not. The way the judge worded it in the beginning sounded almost like she was on the fence about it. B. Lee said the defense better have some riveting testimony this afternoon to make up for yesterday and this morning. I mean, earlier the judge is like, well, you know, we might be here for longer than 3 weeks. I'm like, what? Oh, please rest today. Have your 4 witnesses. Put Donna on the stand, rest. Closing arguments tomorrow, that would be amazing. Is it wishful thinking? Is it asking too much? Yeah, so you say make up for yesterday and this morning. This trial is where bad defense strategies come to die. Shame. And we always try to give the defense the benefit of the doubt, you know, but oh man, this has been quite interesting. Quite interesting. They're doing the best they can, I guess. But you know, yesterday, that jail video... That was long and pointless. That was quite something, right? The Wonder Mom said, gee, it looks like you're trying to peek into the courtroom. I am. I want to see the judge's chambers. Let us in. We want to see what's going on there, right? Oh, my word. Stop it. See, Taylor says, they won't rest today. Donna's cross will be several hours in my opinion. Okay, I can accept that. I can accept she takes the stand today, let's say this afternoon, if that's happening. And then, that's why Donna's probably wondering, should I even take the stand? She looks mighty nervous today. Yeah, because Georgia Kappelman will absolutely rip you a new one. She gonna get you, Donna. You're gonna take the stand. You better be ready for cross-examination, right? Yeah, Sharon said it appears she was in the courtroom. Why? Why? And the defense said yesterday, we will brief our witnesses accordingly. You should do that. One would think, right? Old school girl said, riveting, indeed, like watching a tomato ripen. Well, that does sound quite riveting, actually. Huh? Could watch that instead of what we just saw this morning. Wow. Yeah, the Ninny Fee said, of course Dan was difficult. And I'm going to say difficult. He is a successful lawyer. He was, yeah. And driven crazy by narcissistic Wendi and family. She's not an angel because she was polite to a lawyer. But she had a party called Wendy's Getting Her Groove Back. My goodness. I wonder if I could play you. I don't know. I'm not going to play it in case there's copyright issues, meaning I don't want the stream to be shut down. But there is a podcast, and it's called Wendi Tells the Story of Her Ex-Husband's Murder. And it's called Writing Class Radio. Have you guys heard that? How she speaks about Dan and how she speaks about everything. It's bizarre. So yeah, are we gonna see Wendi next on trial? We'll be watching that together. See, Taylor said, I want to be this prosecution team when I grow up. Me too. Yeah, Charlie said we could watch more of what we were watching yesterday during lunch, but we have lunch plans. What I could do is, let me quickly look at this, and I'll show you a snippet of something while we wait. Which will be, yeah, this. Okay, so let's do this. This is Dan Markel, the victim in this case, speaking at a conference. Let me see what it's called. It's called The Federalist Society is the channel that this is uploaded to. And let's see over here. Okay. Might have to just boost this quickly. There we go. So in case you've never seen this, let's have a look, right? Ainlin said the jail video revealed that Donna is in jail. That's true. That's true as well, right? P.L. Mannequin said, oh, that podcast, Wendi Tells, sounds interesting. It's interesting. I wish I could play it for you. But I will link it. I will link it in the description box for you, okay? So let's have a look at Dan Markel. We'll look at some of his speech.
Thanks, Will. Our second speaker is Dan Markel, speaking about retributive justice and the demands of democratic citizenship.
I just want to let you know that the court has come back. We're going to go in 2 minutes. Let's just see Dan Markel speak a little bit, okay? And then we'll switch.
Greetings, everybody. Thank you very much to Nick and to Eugene and to Todd and all of my co-panelists, as well as to the wonderful folks at the Federalist Society who have been so exceedingly generous to me for this last year. It's an honor to be here and share some thoughts with you about this big project that I've been working on this last year. It's unfortunately an incredibly and an exceedingly long piece, and unfortunately Eugene got tasked with reading about the 130 pages of it. So it's probably going to become the basis of a book, and I look forward to getting your thoughts about it. And let me just sort of give you a few of the bullet points of the argument, and then if you have questions or want to follow up later, you can find me and or download the paper on SSRN. So
Shame. It's nice to see him talk, right? I made this emoji, by the way. If you're a member, this emoji is in honor of Professor Dan Markel. Because a lot of people will say, what's the victim's favorite color? Or how can we honor them, you know, with emojis and things. So I made that one. It's a little professor, you know? I think it's cute. It's like a graduation hat and glasses. So that's in honor of Dan Markel. Okay, so I can show you more of this later. I will also link it. I'll link all my sources in the description box. Now let's just see what on earth is going on in this courtroom as they come back from assessing the sidebar, right? Okay.
So hot from the presses from our very capable court
Wait.
reporters. Has everyone reviewed the transcript?
I picked the wrong one, the wrong feed. Hold on, I want to go back to the other one that was boosted for us.
Agreed.
There you go. Okay. So. What? Yeah, the judge is coming back.
Reporters. Is everyone reporting?
Okay. So I think the jury's still out on their break.
So hot from the presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, Your Honor.
Yes, sir.
Please make your argument.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristin Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now.
Judge,
Why should this witness be permitted to testify, Mr. Zellman?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristin Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristin Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual, or even brought up this topic to make sure we did not end up in this point and place?
Oh my word, I love this judge. This judge is the definition of a lighthouse. Be a lighthouse, not a tank. We learned that from Judge Don Ash in the Sean Finnegan trial. He taught us that, right? And wow, Judge Everett, this is being a lighthouse, not a tank. Yeah, just remain calm and absolutely ask, grill them. Grill them, Judge. What are you doing, defense? This is the second time that you've broken the rules of sequestration.
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Kaplan, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but you did admonish the defense to not let it happen again, and now it's happened again. So, you know, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So,
as to your point of the state getting a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may.
Last word.
Reviewing Earhart, exclusion of the witness. Court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that Proffer can be taken on this matter. After that, I will step down.
Oh my.
Briefly review what I need and make a ruling.
Well, that's embarrassing.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
Okay, Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple weeks ago just to confirm what I supposed were facts. And I have known Kristin for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markel's motions. And she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't.
Okay, but never snark at the presentations, okay? We're protective over those.
Take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendi Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendi Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendi as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristin Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Ms. Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Ms. Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Mr. Kaplan, an examination for the purpose of the proffer.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your preparations?
I think so.
Okay. No, Your Honor.
Please step down, Ms. Bailey. Return in a few minutes.
Well, we're 3 minutes behind, so let's go forward. And in fact, let's just refresh this one. Okay, no, they're still on a short break. Okay, we're back to a short break. The jury was drinking coffee that whole time. Wow, okay, so let me just put a banner. Do you think the judge will allow the testimony or not? Maybe I should make a poll for you. Hold on. Okay. I'm gonna make a poll for you. They better not come back yet before we've all voted, okay? In the meantime, just check if your like button works while I make the poll for you. Okay. Do you think this witness will be allowed to testify? Meaning, what will the judge decide? I'm only asking yes or no. You have two choices. Okay, there it is. Now vote. I actually don't know what I would vote. Do I think she'll be allowed to? Do we want her to be? For the sake of cross-examination? Yeah. Yeah, Little Busy Brain said the jury also needs a lot of coffee today. Yes. Yes, they do. Renee said, don't blame Georgia for being furious. I think the judge will disallow. How do I say your name? Wait. Jobessa Jonah says should not be allowed. Well, yeah, for the sake of efficiency. So we can, you know, just teleport to where we can't actually, because we live, but you know what I mean. Teleport to when Donna takes the stand. Can she take the stand now, please? Can we start that earlier? Thank you so much. Yeah, Gerda said, this judge is a lighthouse with a tank parked inside. Yeah, I think that's what Judge Don Ash also means. He's like, don't be a tank, meaning be a lighthouse, you know? Channel that rage. Keep a calm face. I do like the way the judge addresses things. So if I ever feel super annoyed, I think I'm going to adopt Judge Everett's way of addressing it. Because it's so snarky, but so professional, right? Arcto said Judge Everett may ask Donna if she's satisfied with her defense prior to the jury instructions, just like other trials. I mean, Donna would of course say no. What would she say, actually, yes or no? Okay, so the poll says, do you think this witness will be allowed to testify? Ooh, this is a close one, hey? 51% say yes and 49% say no. Yeah, and I'm right there on the fence between those two choices. Sharon Martin said he might allow it, but will be alert for coloring outside the lines by the defense. Yes. Jessie Lynn says, I don't think Donna will testify. Do you think she's going to chicken out? Because I think the idea is that she wants to testify. They indicated that she wants to testify before this trial even started. So it's actually quite likely. And I think that she's the type who likes control, and she wants to possibly address the jury herself, thinking she can manipulate them like we've seen in many other cases. You know? Like Nicholas Casotis taking the stand. Wow, that trial. If you haven't seen the Nicholas Casotis trial, my goodness. Side note, the lead detective in the Nicholas Casotis, at the Nicholas Casotis trial, the Mindy Casotis case, has passed away. I did post about it within an hour of knowing about it on my community tab. So if you didn't see that, maybe you could check it out. I can actually show you while we wait. Shame. And so condolences to his family and friends. It really sucks when we watch trials together. We love seeing these witnesses. You know, we were all so fond of him, and he passed away. They didn't say how or anything like that. They just said he passed away suddenly. Welcome, Moria. I'll just quickly go like this. Hold on one second. Okay, so I want to show you this, which is my channel. And here's a community, the community tab, right? So it's home, videos, shorts, live, podcast, not by choice. You guys know I'm not a podcaster, I'm a YouTuber. And so I know some people can be both, but I'm a YouTuber. But YouTube sometimes converts things to podcasts automatically. Playlists, okay, and then posts, you go there. If you're a member, you can go there and go check out all the content you missed, right? And so here we go. Shame. Georgia Bureau of Investigations GBI Special Agent Sands has sadly passed away. We watched his brilliant work during the recent Nicholas Casotis trial, sending condolences to his family, friends, and colleagues. If you missed the trial and Special Agent Sands' testimony, I'm sharing the link here for you. Georgia versus Nicholas Casotis. So there is a link to the playlist. Justice for Mindy Casotis was served. Yeah. Whale Chelsea said, gee, maybe show a thank you video to GC and SKD. So abbreviations, Georgia Kappelman and SKD, that is posted on the society page. I don't know what that means. Please can you email me? That would be great. Can you email me the link? Thank you so much for your sticker. I was like, GC, Grizzly Cat, what? Okay, so shame. I mean, we just saw him weeks ago take the stand. So yes, okay, that is a great loss. I'll bring this back up here. I'm sure the judge will be back soon. Let's refresh the page, hold on. Okay. And put this back up here. Sound is on, okay. Kathleen Posey said, Judge just warned them yesterday. He will not allow this ridiculous behavior from Airhead Defense. The judge did warn them. Okay, did I miss another sticker? Mary said what? Where's Mary's sticker? Oh, there. Mary said, how is it that an attorney who's testifying in a case, knowing they're not supposed to be in the courtroom during another person's testimony? Oh, I don't know. Interesting. Thank you, everyone, for answering some of the stickers as well. That's really great. Only one case said, I wonder how much Harvey is paying for his scrunchy wife to win this case. Unlikely, in my opinion. It looks like the defense is botching the job with trying to distract from the murder. I mean, this testimony about the divorce really, I'm sure the jury's sitting there going, wait, what? They've heard a lot about Wendi at this trial. They're going to be like, so when will Wendi? When will we watch Wendi's trial, right? Red says she wants to, but her attorney will tell her not to. I think she still wants to, and her attorney indicated before the trial started that she wants to testify. I would lean towards Donna's going to testify, that she's going to take the stand, but let's see. Are you kidding me? Said if he allows her testimony, he's setting a precedent and not a good one. It's not like him. Interesting. Setting a precedent, yeah. Sometimes people, you know, if they email me and ask for things, whatever, then I also, you can't allow a precedent. I do like that line because it's true, you know. So I don't know what he will decide, but of course this judge is very professional, and I think whatever he decides will be the right decision. Let's see. Teresa said, Donna wants an automatic appeal for poor representation. Yeah, she wants to play dirty. I don't think it's going to work. You know, the judge is overseeing this. Judge Everett is making sure, as best he can, that something like that doesn't happen. Okay, everybody, buckle up. We're about to hear the judge's decision. Thank you, West Texas Gal.
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial, as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give, the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand. If there are any additional matters that need to be clarified, this needs to occur so we don't have any more issues with witnesses or other problems.
He's allowing it? Yeah, Donna, you can't say anything. No room for appeals here. It's different. Yes, Naomi says, so letting her in but giving jury instruction. Ma'am, you're skating on thin ice over here.
Everyone can be seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Thank you, Your Honor.
Here we go.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So,
If you're watching live with me right now, it's 5 p.m. in Switzerland, and you know what that means. If Mr. Grizzly's not in the house, I gotta go feed the cats because they absolutely have built-in clocks and then they know 5 p.m. is dinner time, so I'll be right back.
math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adamson, so
Okay.
we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I initially, during law school and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristin, I am board certified in marital and family law, and what that requires is an application that's about 3/4 of an inch thick that details all of your trial practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, etc. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you've practiced.
And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, Bailey.
Thank you. How many board-certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
Okay. And do you know what percentage of lawyers in Florida are board-certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to.
And they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer review?
They do.
Do you have any other certifications?
I'm a Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education that might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review, and the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests, like have you provided presentations, have you taught, have you done certain community service or pro bono work, that sort of thing.
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines, but at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting.
Are we on the Apprentice show now? Is this a job interview? I don't know. Can we get to Donna? Thank you. Defense.
Related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to voir dire the witness as to their training or experience.
No, Your Honor.
In objection to her ability to provide an opinion.
Come on, Georgia. We want to see you question voir dire, the super lawyer. Come on, Georgia, get up there. She's like, no, Your Honor, nothing there. Okay.
Opinion in the fields of marital family law.
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendi Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendi Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendi Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendi Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendi Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendi Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Okay. Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendi, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristin Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendi Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going, and it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendi Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel, which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed, where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary, but then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendi Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in?
I really wish just once the state would say objection, relevance, so we can just hear them argue about what the relevance is, right?
in place?
No, they worked that out on themselves, by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing.
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now we're using the term time sharing. We also have during the trial heard the term custody.
Oh, timeshare. Yes, bring up timeshare in Vietnam. Yeah, that's where Charlie Adelson had some timeshare. Now he's got timeshare in the jail, in prison. Donna's sharing that as well. She's in jail too. Okay. Again, this is like, if you find yourself zoning out, just know you're not alone. My brain is like, yeah, don't take in any of this. This is not relevant. Don't write anything down. Okay. Yeah, we're just listening. Patiently waiting for lunch so that Donna can come back, have that scrunchie in, and take the stand. And be a sweet, sweet, innocent granny.
Historically, has the term custody been used in family law proceedings?
Not for many years. Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
Okay. And so the term custody is not something that is used in family law proceedings any longer?
Not between parents. There's some, the term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendi Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markel from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell?
Little busy brains. Said the Adelson Dental Institute is now the Adelson Correctional Institute. Oh dear.
The jury, what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now, for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So, in other words, when Wendi initiated the dissolution against Mr. Markel, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review,
Didn't see it, so it didn't happen. Gina Sisto said, Gee, I adore you. Thank you for all the hard work. Thank you for your sticker.
of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markel's motion to dismiss the petition for relocation, and then he had filed a motion to enforce life as he would have liked to have seen it, and then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce. And then...
In other words, he was asking the court to enforce something that they had agreed on but hadn't been a court order?
Well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document. So that was denied.
So let me understand correctly, he was asking for court authorization to be able to go over to Wendy's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just changed their mind. So he was trying to enforce conversations that he had had with Wendy that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it, and he was basically saying that the petition for relocation was baseless and that the court should deny it, and the court said no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendi essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Happy to be here, said, isn't the defense just confirming the Adelson's motive for Dan's murder with his testimony? I mean, the jury's not going to forget that the victim in this case was murdered. So to minimize the divorce, to say it wasn't really that contentious or focus so much on Wendi and on Wendi and Dan's divorce, is it really helping Donna's case? Really? I don't think so.
Subsequent to the June 21st, 2013 hearing, did Wendi Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendi waived alimony, they adjudicated child support, they put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now
Your Honor, could Donna Adelson perhaps, become part of this conversation? Maybe a way we could do that is if she could just throw her scrunchie towards this witness, because it seems like the witness's hair is bothering her a lot. Will that bring Donna up in the conversation? Or are we just going to continue to talk about Wendi and the divorce? Okay.
marriage settlement agreement also put in place a parenting coordinator?
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristin talked about that earlier. And you have to, it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change, and the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson Markel case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No, they resolved everything. Temporary parenting, permanent parenting, support, property.
How many months elapsed between when the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial.
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
No, to the contrary, it was settled amicably and everybody was moving on with their lives.
And quickly?
Yes.
Really?
During the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adamson spoke out earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery?
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendi about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days, and then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company, you know.
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140-something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendi Adelson's divorce.
None of that happened.
Okay, Dr. Patrice Berry said, I'm catching up, be a lighthouse, not a tank, love that. If anyone wants to look up Judge Don Ash's blog, he has one, and you can say, Judge Don Ash, be a lighthouse, not a tank, put that in Google or Safari or whatever, and it should come up like one of the first results. So then you can read how he explains that concept further, which is really great.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool, where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
Okay. And aside from those two, were I believe Wendi, was she deposed?
I don't recall seeing that Wendi or Mr. Markel were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Okay. Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved.
Nurture them is what I heard there in all that bullcuck. Nothing unusual. Just Wendy's mother wanting to edit some of the drafts, of the filings. Also saying, let's make Dan's life absolutely miserable. Let's make sure that you do the performance of a lifetime, Wendi. Huh? Tell Dan that you're raising the kids Catholic, which would be offensive to him and his faith, right? Okay. And all the other things we already know she said. Let's not repeat it again. But nothing unusual. Nothing at all. Not a contentious divorce. They were just moving on with their lives. No, they weren't. Wendi was stuck in Tallahassee. Wasn't allowed to relocate the kids. Okay? No one was just moving on. My goodness. And Donna? No, your level of involvement was way beyond domestic coordinator, okay? Maybe she was a super domestic coordinator.
Family involvement, and especially moms, I see a lot.
A lot of mothers.
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to just to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this.
Objection, speculation. You don't know why they said it or what their secret little reason was for saying gibbers. That's one option. We've looked at the options ourselves before, like why gibbers? What's the reference exactly? Could be the gibberish, could be a lot of talking, but it's derogatory. It's inappropriate. But okay.
Case. It was somewhat applicable. He was very verbose. If you looked at his...
You're literally agreeing with Donna Adelson that gibbers was somewhat applicable. Get off the stand.
Writings, as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent, they didn't make sense, they referred to, in multiple situations.
Ma'am, he was a lawyer. So was Wendi. She's not a lay person, okay?
Situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16.
I'm just letting you all know I'm confessing that I have my middle finger up over here that you can't see. It's just involuntary. It happens, okay? Now I'm getting angry. Please do not go down this path, lady. Stop victim blaming, okay?
Page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendi Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them. And he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendi filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so dollars. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to
Interesting, because he won in court.
the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client, in the emails you review, appear to push back on Wendi and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st.
Right, so what I saw from what I was provided, it sounds limited. Would you like to, come on Georgia, show them tab whatever it is, tab 54, go there. Let me show you the highlighted portions of this, and this. You see that? You see that?
And there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendi responded, I think at the end of that, Mom, I'm at peace, I'm good.
Oh, she didn't. A perjury. Off the stand you go. Get your ass out of here. No. Wendi did not. Did you see that? I don't see that. Wendi, I'm at peace with it, Mom. Let it go. I don't see Wendi say that ever. Am I wrong? Tell me if I'm wrong. What? No way. If she said, Mom, back off. Okay, I can understand that. But that? I'm at peace, Mom. Just let it go. No, you lying now. That was so not the case. My goodness.
And then they dropped off. There was no more communication.
No. No, none of that. There were many suggestions, including offering. One could call it bribing, but let's say offering for relocation costs, $1 million that Donna and Harvey would pay a third of, Wendi would pay a third of, and Charlie would pay a third of. Yes, to get Dan to agree to let the kids relocate. And he would not budge, although there's reports out there that he wasn't even made the offer yet. But that's on email that was their plan, right? My goodness, yeah, you guys are like, never was said. That was such a lie. Don't worry, Mom, I'm at peace with this. Do you think the jury's dumb? The jury saw things, okay? They heard things and they know things.
That I saw
And then
between them.
certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
What? Not that I saw. Then look again, ma'am. Put a hair clip in. Put on some glasses and have a look closely. Maybe a microscope. You see that? You see that? A lot was said. A lot of plans were made. And that's the whole point of the case. Things escalated to hiring a hitman. Yes.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position, and maybe theirs will change.
Now, you were provided with a number of emails that Wendi was sent by her mother. Did you see evidence that Wendi shared those with Kristin Adamson?
I saw no evidence that Wendi shared them.
Okay. And did you speak with Ms. Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendi Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days, with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for, and that was to last 3 years, and then it went into 50-50. I think that got the youngest child to school, maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, the division of child care, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, child care, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that.
Put Jeff back on the stand. Jeff Lacasse, tell us again what Wendi was up to. Huh?
Because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that, by agreement.
And you mentioned keeping the boys kosher. Was Wendi Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendi Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
What?
Sarcasm says, anyway we could speed this up a bit, asking for 8.6k friends. Unfortunately, we're watching almost live, so not really, but because we're about 6 minutes behind the live, maybe a little bit. I'll try a little bit.
Was Wendi Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say you need to go to your therapist and follow their advice.
Was Wendi Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements because kids don't want to see their parents fight every birthday. Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement? No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendi a lump sum and Kristin Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendi Adelson and $10,000 towards attorney's fees to Kristin Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendi Adelson?
Yeah. Yes.
Now, later...
But it's very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
So from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments from Mr. Markel were due within 60 days, so that would have been due at the end of September. And so, taking Kristin Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she
Correct.
waited to file.
She did.
Okay.
And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails from between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendi to do anything about relocation?
Not that I recall.
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendi was going to be staying in Tallahassee?
Yes, it was done.
Sure.
When you say it was done, what do you mean?
I mean, Wendi waived her right to appeal that by agreeing that the relocation would be dismissed. So,
Now, prior to final judgment being entered, would Wendi have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
she could have.
Would there be anything improper with Wendi or her family through Wendi offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide-ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation, so that's routine.
Nothing unusual about
Routine.
that.
Nothing unusual, except the negotiation didn't go as the Adelsons planned. It was rejected, allegedly, or Dan didn't even get to hear about it. But it was allegedly rejected. Their plans were going nowhere. Negotiation done. No relocation. And then the grandma motion. No unsupervised visits with the kids because of the crap that Donna was saying to the kids. Saying that their own dad is stupid. And they say, why? Because he's trying to take my sunshines away. Oh, okay. Nothing unusual, says this attorney. Really?
Now, you testified earlier that you were provided text messages between Wendi Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it was a few months period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Interesting how it ended in murder. That's why we're here at this trial. You also watched Charlie's trial, did you? So you know that there's already been 4 convictions. The victim was murdered. Read the room, right?
Now, you indicated earlier that October 31st, 2013, Kristin Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness?
It's binder time. I went forward like this.
An approach with courts 1 states demonstrative A, specifically page 338.
Even Donna is tired of this.
Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause, and under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendi is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here, she's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristin for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
So, defense, less is more. This is a lot. This is a lot.
In the scheme of this dissolution and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markel?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markel emailed the parenting coordinator and Wendi Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendi in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendi to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
What in the hell, woman? He didn't ask for that? You didn't read the grandma motion? He didn't ask for that. He just said to Wendi, he being the victim in this case, who was murdered. This attorney is saying, according to her recollection, Dan Markel just told Wendi, be mindful that your mother is telling the kids that I'm stupid. Okay? There was a huge, massive, motion filed about this. Referred to as the grandma motion in this case.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kids said something like, Grandma thinks you're stupid, or something like that.
Did Mr. Markel file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markel?
I'm sorry, Mr. Markel's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendi had these other financial violations. And then she referred to the Schwab account that you've heard about, and a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendi. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues.
So you can recall these dates on the fly. This one was filed on that date, that without really looking at notes. But you can't remember the grandma motion. But the jury can, I'm sure. We can. Anybody else not remember it? If you saw the testimony at least, and the evidence of the grandma motion. The very motion that, firstly, Wendi lost her relocation motion. And then there was this grandma motion to prevent unsupervised contact with the children, because Donna was saying things to the kids about their own dad. That is what one might speculate, plausibly, set Donna off on this plan. This is Donna on trial. By the way, defense. Don't know what this has to do with anything, especially if you're going to try and gaslight people that didn't happen. Never saw that. Dan just said, be mindful that your mother is saying mean things about me. Yeah, right. Really? That's next level gaslighting. Oh my word.
He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendi Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then, according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that, and it wasn't legally supportable.
That's not a valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
And neither is this. I said it with a very snarky smile. This is not a valid defense either. Don't be snarking at the victim who was murdered and say, that's not a valid defense. This isn't either. Thank you.
Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you and didn't disclose, or that they had some stash of Gold Bar somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle
Sure,
to
and it had
overcome.
to have impacted you. In this instance, it was clear from Mr. Markel's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some
Don't worry, Donna is here. She's ready for her nap. She's also wondering, what does this have to do with me?
of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendi on the financial issues February 14th. And then towards the very end of March 26th, after Kristin had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for, there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go have dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them. And they were little babies. And he didn't like that because he wanted to be able to go to the childcare during her parenting time so he could see them every day. And I think the childcare person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful. Yes. Yes, it looks like on April 11th. Nope, that's his response. Let's see. Yes, it was before my recollection was correct. She filed a motion to dismiss on March 10th, to dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
Motion?
Correct. And then that was all set for hearing for May 15th.
Okay. The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made, well into this very long motion, was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
I'm sorry, but how unprofessional and biased can you be here? Just like, oh, he was just so annoying with like, it was like his 8th filing. Hello. Stop saying that about Dan Markel, who loved his sons and was fighting to spend as much time with them as possible. You, as a family law attorney, should know that. Because you would have clients from either side, right? Men and women, moms and dads. So why talk about him with that tone? Well, clearly because maybe Harvey's paying for that. But why? Just keep it neutral and professional, man. To be like, oh, he was making this filing and psh, right. It's so upsetting, my goodness.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show a material and substantial change in circumstances and that it was in the best interest, and there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Okay. Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No.
Look how worried Donna is. She's looking at the jury like, oh crap, yeah. I think our collective faces could be the jury's faces right now. Possibly super annoyed and like, really? You just said that? Wow.
It was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in this motion, he says, I don't know if this is true or not. I don't know if Wendi was present or not. But I would like Wendi to make it stop if it's true.
Do you know what makes it likely that it was true? That the family hired a hitman. Already proven with Charlie, sentenced to life without parole for his role in hiring the hitman. Now Charlie's mother is on trial because of the conversation she had with Charlie, saying it involves the 2 of us, because of her reaction to the bump, because of her one-way ticket to Vietnam, because of all the angry emails. It's all together, collective, circumstantial evidence with some direct. I think at this point, the jury might lean towards, perhaps very strongly, believing that the Adelsons were not going to react well to all of this, right? Really? You want us to believe it was just peaceful after that? Right.
Did this motion, the March 26, 2014 motion that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Why? Why do you say that? Why do you say that? That is what the grandmother motion is. I'm not an attorney, and I know that. We saw it. The grandmother motion is that Donna cannot have unsupervised visitation with her grandkids anymore because she is trying to influence their opinion of their own dad. I mean, no, that wasn't in there. Really? I really hope the state, I hope they cross-examine the super attorney. Hey, she said super lawyer herself. Super lawyer, okay? Please cross-examine and show the grandma motion.
Markel requests that my client's time with the children be restricted.
The only thing he requested, and he had the first right of refusal, maybe 0.4 or 5, and then he kind of tied in this grandparent thing on 0.8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school, so he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendi to have to call him so he could watch the kids even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if, my rule, or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. That's a normal part of a kid's upbringing, and so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Okay.
Dan Markel referred to it as grandparental alienation. Wow. Southern Cali B said, if G is letting us snark at a witness, you know it's bad. I know it's really bad. It's because of the victim blaming and bashing. So if anyone's only joining now, that's why. So it's very difficult. It's almost impossible to not get angry about this testimony. And it's the second one in a row now. This has not been a great day because this is about justice for Dan Markel. And the defense's case has turned into absolute slander and victim blaming and bashing. It's just so terrible.
Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar to what Ms. Adelson described the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all because it was a complete waste of everyone's time and money and emotion because it was baseless. It didn't tie to anything.
Baseless? What? You're calling now his claims baseless when we know that Donna called the grandkids sunshine. She even called Wendi her sunshine when Wendi was growing up. So when the kids were apparently telling Dan Markel, Grandma says you're stupid, and he says why? Because she says you're trying to take her sunshines away. That's, Okay, Southern Cali B said, the backlash this woman is going to receive gives me anxiety. Oh my word, justice for Dan. What is this truly about? I know, right? Wow.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his violence?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify terms.
In reading the motion, does it appear to be intimidating?
No, I think when I was making notes, I put insert by role here. It was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Okay. Nancy said she's basically bolstering motive. I think so too. The comment that I had up earlier, where is it? Oh dear, I gotta try find it. You were saying that they keep pointing out, there we go, they Simply B12 said, I really don't like this lady. She's trying to paint him as the problem. I'm starting to like it. You know why? Not because I like victim blaming or bashing ever, but because this is backfiring already, even though it's still direct examination. Because what we're hearing, which I'm sure the jury's hearing, is, oh, so the Adelsons did think that Dan was a problem. You even think he's such a problem, and that he talks too much, and that he needs to be what? Silenced? Stopped? Stop filing these baseless claims? Really? So I think it's actually bolstering the state's case. I agree.
Should Wendi Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have, and that's one of the reasons I wanted to call Kristin, because again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense, and I wanted to get Kristin's take on that and see if she agreed, and she did. And she.
Well, we all kind of thought, we were taken aback when you were sitting listening to testimony in the courtroom. And I think the judge thought that was nonsense.
Said that she had advised Wendi of that, and that's what I would have expected from her.
In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendi had sent her mom a couple of documents. I know the petition for relocation, that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions, because, like Ms. Adamson said, relocation is extremely difficult, and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition.
So you need as many facts as you can have to support yourself. But if Dan Markel does that, that's just, it's too much. It's gibberish, huh? Too much noise is what this attorney called it. Too much noise.
But after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markel have been able to sustain his burden of proof for that motion?
I'm sorry, say that again?
Would Mr. Markel have been able to sustain his burden of proof for that motion?
No, I don't think so at all. If you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay, and I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just, there's so much worse that goes on that's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case or a high conflict case. how many pages are in the court file?
I think there's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markel that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Okay. Do you know how much in attorney's fees Wendi Adelson incurred, attorney's fees and costs, for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adamson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
Okay. In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
Your Honor, may I show the witness the demonstrative?
You may.
Must be cold in the courtroom today, or what? This lady's got a jacket on. Jackie Fulford, the attorney here, looks like she's freezing her ass off too. Moonchild says everyone's going to get 3 credit hours for Family Law 101 combo course. Can someone please print out a certificate?
Volume 3. Volume 4. Volume 5.
There's a question for the witness.
Do you recognize this file?
Yes, I think I forwarded this to you.
And these 10 volumes a example of a hotly contested relocation case?
Well, I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
Oh, not contentious though, you say. Say it again. Not contentious.
And there were 2 volumes on the record on appeal, so perhaps only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
This is Alan's witness.
Wow, and what does it mean? So Dan Markel, he filed a lot of motions. A lot of papers there, guys, from an FSU law professor, might I add, fighting for his children so he could spend time with them in this non-contentious divorce, hey? Okay. So what's the point of showing this, though? That what, he deserved it? Or what, that he needed to be silenced? Because I don't get it. I'm sure the jury's saying, okay, all right, so that's a lot of papers. Now what? Yeah, Stefan said, not contentious, just an ugly divorce. Semantics, hey, that's what they're doing. It wasn't contentious. No, not at all. Kathleen said, yes, I think I forwarded this to you. Mm-hmm.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Yes, please
Sustained.
object. Sustained. Finally,
Judge,
yes.
may we approach?
No.
Judge, we're entitled to make a record. I believe I have the...
Members of the jury, the bailiff will take you to the jury room.
Oh dear.
seated.
That's another case. They're showing an example. Then it's even less relevant. Look at this. Look at all these filings. And this has to do, exactly. Judge, send the jury out and let's address this matter. Oh, this is so... It's testing our patience, hey?
Relocation issues within this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendi Adelson and Mr. Dan Markel.
Compliment.
Taking chances, are we? Sure, this guy. It's quite brave, eh? Wow, really? Yeah, it's getting spicy, Jinxie. So that, all those files weren't even Dan Markel's findings. That was just another case. They just want to show it in comparison to Wendi and Dan Markel's divorce case. Really? Come on. Look at him. You know you're taking chances, sir. Damn. Brave to take on this, Judge. Sure.
Any other argument on this issue?
It's relevant, Your Honor.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce files certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
Ms. Bailey, please step down, step out of the court or the courtroom doors. If you can radio Deputy Bunk to leave the jurors in the room, please approach.
Damn, this is a dramatic trial day. Molly the G said, "Hi G, good morning from Los Angeles. And good evening from Switzerland. Here at 6:30 p.m. if you're watching live with me." Let me know where you're watching from. While we wait to see what the heck is going to happen here now. Oh, okay. Looks like they're going to take a break. Your Honor, we need a lunch break. My client needs her energy so she can maybe take the stand later. Yes, please. Go get your, I don't know what Donna will have. Spaghetti and mashed potatoes. All carbs, as she complained about. Sure. Now we wait. Yeah, Pernille said, "I hate that he argues with the judge or the court. Not appropriate."
I'm going to remind you, do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. The jurors using the restroom.
They are.
Please use the restroom or stretch your legs if you need to. We will continue with the witness after that.
Okay, no lunch break. Not yet. Everybody close your lunch boxes. We can skip forward at least.
All rise, they're entering the courtroom.
Tracy Pope, you're up early. You're watching from New Zealand at 4:34 a.m. Damn.
Everyone can be seated. Please continue with your examination.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases that you've handled?
simply. It was routine. It was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic. He used a lot of inflammatory language, but when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you agree with that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. That's one reason I called Kristin, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy, but there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendi.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with
Perhaps.
that. You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey.
derived.
To that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't
Exactly.
It shouldn't have been. There was no proof,
It shouldn't have been, in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay. Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And
I
Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's not a question that we should strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on the witness's testimony.
Sustained. Please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendi. Jail is not a possibility on that, but you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristin was more debatable because that could have been in the specter of support, and if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays and he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristin the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 to Wendi. It was only the $10,000 to Kristin that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendi taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendi then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text message, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were... I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October, maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right, and if he was murdered, it could happen, right?
Well, obviously.
Obviously. Mm-hmm.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motion in March 26th related to parenting He was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well,
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
if there wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
Yes.
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Oh, Georgia is so brilliant. Jennifer Hendrick said she understands why Donna was upset, but not why Dan was upset. Amazing, right?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristin of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection, Your Honor, calls for speculation.
Overruled. The witness has provided an opinion. The state
Well,
will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendi have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen, because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
Go ahead.
Oh, that was so satisfying, that cross-examination. Thank you, Georgia. Donna, you feeling worried, huh? Gonna chicken out, aren't you? It's an interesting face she's making. Okay. A bit of tension there, like, You don't like that, huh? Smells like bullcock right here, huh, Donna? Thank you so much, Kelsey. Donna can no longer see the light at the end of the tunnel. In my opinion.
Redirect examination.
Briefly, Your Honor.
Ms. Bailey, you sat through Kristin Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Hopefully not. The defense is like, boom. No, not really, defense, not really.
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day. Members of the jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break.
Donna, you've got some big decisions to make. Thank you, Sharon, for the sticker. Donna, the time pressure's on. I think there's one other witness. Wait, we've only seen 2 so far. There were supposed to be 4 before perhaps Donna would take the stand.
Everyone can be seated. Any discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point. Are there any other matters that we need to address?
Judge, I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court cautioned the gallery again. I don't know what steps the court needs to take in order for that to stop, but the fact remains that they're doing this in front of the jury, could have an impact on the jury, and could impact my client's right to a fair trial.
Well, this is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed. Are you able to identify them?
They're behind me, Your Honor. No, all I can identify is it's coming over my right shoulder.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you are engaged in a disruptive behavior that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. I cannot make this any clearer at this point.
How do they know it wasn't the defense's own witnesses sitting in the back? Twice now. Okay. Maybe it's them going, oh, no, you didn't.
Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Ms. Descalzo, I believe, is still to be called by the defense.
Yes, Your Honor. Mr. Descalzo and Ms. Newhouse are slated.
Concerning the rule of sequestration, the remaining witnesses understand they are not to be in the courtroom.
I'm not aware that they have been, Your Honor.
Please scan the courtroom to make sure none of your witnesses are present, so we do not have.
Yeah, scan the courtroom and tell us if it's them that's going, oh, no way. I'm testifying next, I'm testifying next. Maybe it's them making noise. Caroline says the light at the end of the tunnel is an oncoming train. For Donna, yeah. If she's seeing any light, shame, Donna. Stefan said Zalman is in complaining mode. He knows his case is going south. Yeah. Way to deflect.
And continuing violations of the rule of sequestration.
I don't see any witnesses in the courtroom, Your Honor.
Please return at 2:15.
Are you sure? Because they were sitting right behind you twice. The first time you didn't even know. You guys were texting, looking in the hallway, looking everywhere except behind you. Behind you, he was the realtor from yesterday, if you guys missed that drama. It's actually timestamped drama for you on day 7 of the trial. Okay, let's just see how they go forward. Okay, so now it's lunch break time. Okay, so there's many things we could do. One of them being, let me quickly see. I wanted to show you this filing. Okay. There we go. So, thank you to Grizzly Cat for sending me this. I'm going to read you this. It's, I think, 3 pages worth of writing. Whoa, Court TV. Court TV getting the music going. Excuse me, we're trying to talk here. I object. By the way, I'm going to be on Court TV at 9 p.m. Eastern today. Today is September, is it already September 3rd? Damn, September 3rd of 2025. If you're watching live with me, you can find me on courttv.com, on the website, live, somewhere between 9 and 10 p.m. Eastern, which is between 3 and 4 in the morning for me. So don't tell me you have to go to sleep, because I won't be. I'll be on Court TV. Talking about this case, okay? So if you want to see me more after today's trial, you can see me there. Now, this is something that Grizzly Cat sent to me, a tribute to Professor Dan Markel. So there's some of his students, lots of people, family, friends, students wrote tributes to him and about him after learning about his murder, right? And so we're just going to read you this one. And again, if you've been here for other trial days, this, normally we defluff. This trial, we're not defluffing, right? We've got a full fluff buffet, so we're going to look at lots of different things during this lunch break. They said they're coming back at 2:20 Eastern. So in fact, let me write that back at 2:20 Eastern time. That's local time there, so you can convert that to wherever you are, okay? That's important, is local court time. So right now, it's 1 o'clock, 1:02. So we have an hour and 20 minutes or so to listen to things, watch things, all of that. Bianca T, welcome. So this is a tribute to Professor Dan Markel by Keith L. Savino. The first day I met Professor Dan Markel, I was prepared to walk into his office and tell him I was dropping his class. I was enrolled in his sentencing law and policy seminar, but had also recently been invited to become a member of the Florida State University Law Review. As a new member, I was required to write a lengthy student note, and I decided that completing papers for both Professor Markel's seminar and the Law Review in the same semester would be too burdensome and well beyond my capacity. In my mind, dropping Professor Markel's course was the obvious choice to lighten my workload. Okay, wait, let me just expand this for you. There you go. All right. After we exchanged introductions, I told Professor Markel about my dilemma and my regretful decision to drop his class. He told me that he understood my plight and was glad I came to speak with him. I was relieved that this awkward exchange was about to end, but Professor Markel continued. He looked at me and said, "The vast majority of law students in your position would do the exact same thing. They would take the easy road in the face of something difficult. Only a committed few would do both. Do you want to be in the majority, or do you want to see what you're capable of?" I was rendered speechless by Professor Markel's proposal. He told me to take some more time to weigh my options and said that he would know my decision in 2 days on the first day of class. In the time that has passed since Professor Markel's shocking death, I've heard countless similar stories of his unbridled passion and enthusiasm for pushing his students and colleagues to succeed and to reach their full potential. I decided to stay in Professor Markel's sentencing and law policy seminar, and it became one of my favorite and most rewarding courses in law school. I was among one of the final 2 classes that he would teach, and given the small, intimate nature of my 5-person seminar, I developed a wonderful relationship with Professor Markel. Thank you, Daisy May. His mentorship and advice throughout that semester transformed my writing and legal reasoning, and I owe so much of my growth and maturity as a future attorney to Professor Markel. Experiencing a Dan Markel class lecture was truly witnessing a force of nature at work, Within a few weeks of the semester, I was convinced that he was the most brilliant person I'd ever met, and I was continually awed and oftentimes completely confused by the ease with which he could posit and discuss complex sentencing law theory. During one lecture in particular, Professor Markel intricately explained the facets of his retributivism, sentencing theory. I think I said that wrong. Retributivism. Sentencing theory as applied to the character Jean Valjean from Les Miserables. Did I say it right, Stefan? Did I say the French thing right? Les Miserables. Okay, after an almost 15-minute long monologue on how Valjean fit the retributivist principles, I asked Professor Markel if he often used Valjean as an example to explain that. Professor Markel laughed and said that it was just something that came to him off the top of his head. Like I said, a force of nature at work. Beyond the confines of the classroom, the truly remarkable Professor Markel revealed himself further. Throughout the semester, we would meet every Friday to talk about my paper and to hash out ideas on how to improve my writing. It was through these discussions, oftentimes sprawled out on the couches near his office, that I came to know Professor Markel as the man, legal scholar, and loving father that he was. We went through many stages of the writing process together, and I experienced the brutally honest critiques and comments that he's famous for. I did not know how to react when he told me that my first draft was mediocre at best, or when there was a giant red X through the 3 pages, but we eventually graduated to now you're showing me what you're capable of, and then you've created something very special and thought-provoking. Oh, Stefan says perfect French pronunciation. Is that so? I do live in Switzerland where the national languages are Italian, German, and French. So I hear a lot of it throughout the day. Okay. So it says, it was through Professor Markel's relentless desire to push me and to demand my best that I truly expanded my ability to think critically and to challenge conventional norms through my writing. The lessons and techniques that I learned from working one-on-one with Professor Markel have transformed my legal scholarship, allowing me to reach beyond my self-imposed comfort zone, challenge myself, and emulate his work ethic. We would often joke that Professor Markel probably never slept. You know, you guys say that about me too, right? Maybe none of us ever sleep over here, but he just sounds amazing. I'm so glad that students wrote these, right? Wow, okay. We would often joke that Professor Markel probably never slept given the amount of things that he would accomplish in one day, but it was obvious from working with him that he strived to be the best in his field and had a staunch commitment to his work that few can claim. A tribute to Professor Markel would be incomplete without mentioning some anecdotes that capture his personality and zeal for life, and I would like to share a few. While I was writing my sentencing law paper, it was not uncommon to get an email from Professor Markel at midnight or 1 a.m. with links to law review articles or New York Times op-eds related to my paper topic. He would include a quick sentence saying, "Thinking about your paper, started looking up some materials and came across this. Hope it helps." I was always struck by these emails, and they speak directly to Professor Markel's investment in his students. He was unequivocally devoted to our growth and progress to the point where he would analyze and think of ways to improve our work, even at absurd hours of the night. It was instances like this that made me want to work even harder for Professor Markel and to put the same level of effort into my work. Professor Markel is well known for connecting people and for sharing his vast network of friends and associates, and he spared me no exception. When he found out that I would be interning in Washington, D.C. over the summer, he took it upon himself to contact his friends who lived in the city, send me a complete list of restaurants to try, and recommend the best places for live music, good drinks, and somewhere to unwind after work. I was working in Washington, D.C. when I found out that Professor Markel had been killed. I will never forget walking out to the park across from my apartment and sitting on a bench for hours, numb, not wanting to believe the news that I had just received. Finally, the largest and most important aspect of Professor Markel's life was his 2 sons, and he used every opportunity to express his love and admiration for them. During one of our Friday sessions, Professor Markel was obviously distracted on his iPhone as he kept scrolling through something while wearing a huge smile on his face, one that expressed pure joy. Sensing my frustration, Professor Markel flipped his phone around and excitedly showed me pictures that he had taken of a painting that Benjamin, his son, made. He told me that he was so overcome and happy by his son's artwork and that he could not stop looking at it. Professor Markel showed me more photos and boasted about how perfect his boys were, with that huge smile on his face the entire time. I'm forever grateful to have witnessed this type of love that a father can have for his sons. The final time that I saw Professor Markel, he invited our seminar class to his house for the traditional final class dinner. We were looking forward to this final class all semester, which included dinner, personally prepared by Professor Markel, and then a group of peer review of our papers. When I got to his house, Professor Markel was bustling around the kitchen in his socks, putting a vegetable lasagna in the oven, making a homemade guacamole, and filling wine glasses. It was impossible not to notice the string hanging across the living room ceiling holding Benjamin and Lincoln's vast array of artwork. Fight for Dan says, follow the rules now, defense. Really? Right? Exactly. Okay. So, given the unsettling tragedy surrounding Professor Markel's death, I am comforted to have this positive, happy, and final memory of him. We spent the evening laughing over dinner and had a very thoughtful and encouraging peer review led by Professor Markel's uncanny ability to facilitate the discussion. I shook Professor Markel's hand as I left, and he reminded me that if I ever needed anything over the summer or if I had any questions, law school related or not, he was always there. Although 6 months have passed since his death, I still have to catch myself from waking up to his third-floor office in B.K. Roberts Hall, wanting to tell him a piece of news or to ask for his advice. I want to update him on things in my life and ask him whether he agrees with my decisions about classes, job interviews, and plans for my future. While I have to remind myself that things are no longer possible, these things are no longer possible, I carry with me the things he said, the emails he sent, and the values of hard work and devotion that he instilled in me. I will never forget Professor Markel, and I will do my best to keep his memory and spirit alive. Isn't that amazing? Oh my word. Stop it. You guys are going to make me cry. That's why I'm not looking at the chat. Don't make me cry now. Whale Shall See said, don't forget Romansh. Switzerland has 4 national languages. Is that so, Stefan? Is that so? Is it 4 national languages, or is it 3 national languages and some Romansh, or is it 4? Please educate me on where I live. Have lived for over a year now. Yomar Vasquez said, I think... Wait, I can't read that whole chat. I've lost it now. Sorry about that. Okay, so we have another one of these if you want me to read it. Do you want me to read it now? Maybe we could take a short break here, but I want to show you just more of that I was showing you earlier, which is actually Professor Dan Markel speaking at a conference. So while maybe his topic might not interest you, I'm pretty sure you guys would be interested in seeing him speak if you haven't before, right? Okay, so go like this. So we could do this, and then I could read you one more if you want. Okay?
The paper is about the tissue connecting democratic citizenship with retributive justice. And the argument is that contrary to some of the leading criminal law theorists like Michael Moore or Doug Cusack, who insist that in order for the criminal law to be retributively just, it has to be predicated on moral wrongdoing, I argue that we need to, or that we can, as retributivists, loosen up on the criminalization question and move beyond the insistence on moral wrongdoing as a prerequisite for justifying retributive punishment, at least in liberal democracies. And that qualification of at least in liberal democracies is really quite important. In addition to the thesis that there's more flexibility in terms of what plausibly justifies retributive punishment than simply the existence of evidence of moral wrongdoing, I also argue that retributivists have to show some respect for democratic lawmaking when it applies to sentencing, but the sentencing issue is distinct from the criminalization question. And if I'm right that there is some kind of way in which democratic authority can generate new moral obligations for citizens, then there are at least some counterintuitive implications that arise. And I'll tell you what they are. So first,
Right, so there he is, hard at work, doing his presentation. I just thought I want to show you that just so you can get a preview so that I can link it for you and you can go watch the whole thing if you want to, right? Stefan, You said, yes, it's 4 languages. Romansh is an official language too. That's cool. I don't know that. You know why I don't know that? Because I realized with citizenship, I think they want you to speak one of 3. Italian, French, or German, like fluently. Working on my German for one day. When I'm big. then I'll be, sprechen Sie Deutsch, ja? Sehr gut. Thank you, Stefan. All right. So I have one more to show you. Hold on one second. So we read that one, right? Let's just see. Is it this one? Okay. So we have this one. Okay. So we have another one of these that we're going to read. And then let me quickly just put a poll up so that you can vote on what you want to listen to next. Okay, so hold on one second. What do you want? Let's just go like this. I'll do it quick. Like what's next? Okay, like this. I've got some options for you. Continue. We could either continue the cross of Charlie Adelson from his trial, okay, or here comes option 3. You'll see it now. And when I say Donna transport video as an option, I mean when she's having her like anxiety moment in the transportation, okay? Being very, very dramatic. Okay, not to ever minimize panic attacks or actual anxiety attacks. I don't know if she is having one or not, but like my word, she was very dramatic. If you haven't seen it yet, we could see it together today. So those are some of the options. It's not the only options, but I'm giving you some choices there. While I read this to you, you can vote. Okay, please also check that your like button works. I see more than half of you have done so today. Thank you so much. Okay, so what is going on here? All right, so we're going here to page, there's 5, so it's 2, 3, there's only 3 pages of this one. Right. Okay, let's get ready to read this. It says, Dan Markel's premature death cements his uncompromising legacy by Ryan Wexler. You know, they say to never be late with a cup of coffee in your hand. 2 seconds prior, I stumbled through the door of Professor Dan Markel's criminal procedure adjudication class. Thermos in hand, 1 or 2 minutes late. The door to our classroom was noisy and the audience was limited to about 10, so all eyes pounced on me as I abruptly entered the room. Under Markel's scrutiny, I immediately blurted my excuse, traffic. Although my excuse was true, Markel's immediate and witty rebuttal proved it to be illegitimate. I should have skipped making coffee. Brilliantly assertive, brutally honest, and tenaciously disciplined. That's just so nice how they describe him, right? Markel wore these attributes like a potent cologne. At the Florida State University College of Law, where he taught, Professor Markel's name carried a mystique that excited some students, terrified others, but marveled all. Before even meeting him, you would have heard the stories of Markel calling on the inattentive student who surfed the internet, interrogating the unprepared student who lied about completing the reading assignment, and dismissing the disruptive student who, from the back row, too loudly discussed the weekend's football game with a classmate. Effectively, Markel's expectations were disclosed before he ever handed out a syllabus. But those students who evaded campus gossip and were unaware of Markel's demands quickly found out, and hopefully not the hard way. To be fair, Markel's dominant classroom command befell his brightest and most diligent students as well. I admittedly was not his brightest, but because of my passionate interest in criminal law, I was diligent in both classes that I took with Markel, and I frequently contributed to classroom discussion. Typically, the unwritten rule in law school is this: law students who voluntarily raise their hand to participate get a pass of sorts. More specifically, law professors usually restrict the harshness of their logical attacks on students' volunteered comments in order to encourage voluntary classroom participation. I'd be so screwed in a class like that because I am not the type to like put my hand up. I'm more like somewhere in the middle or in the back, be like, don't call me, don't call me, don't call me. Okay. So it says, some variation of this rule was followed by every professor I took in law school except one, Professor Markel, who adamantly abandoned it. Nice, okay. Moreover, because Markel's curriculum and teaching style were largely theoretical, his classroom discussions were prevalent and combative. When I was really on my game, and on days when my intuition was particularly strong, I could withstand 2 or 3 verbal exchanges before Markel would stump me. But it was never about winning or losing when you went up against Markel. In fact, you were never against Markel whatsoever. It was a mutual learning experience, and that is what made his teaching style so fun and effective. Whenever I contributed, Markel would carefully consider my input. A brief delay in his rebuttal meant I might be onto something, and then meticulously unravel it. He treated students' insights like pieces of scholarship to which he was obligated to critically respond. No one has ever unpacked my thought process in the way that Markel was so instinctively able to do. When I reflect on the times I went back and forth with Markel, I realize that they were the greatest moments of learning that I ever experienced. What I learned goes far beyond the intricacies of criminal law. Markel taught me how to think critically at a level I never had before. And that is a lesson Markel gave me that I will carry for the rest of my life. Still, there was much more to Dan Markel than the militant professor and scrupulous scholar, and I am fortunate to have known the human being beneath the renowned academic. The first of 2 dinners that I had at Markel's house revealed the contrast of who Markel was at home in comparison to who he was in the classroom. Markel invited the students in his sentencing law and policy seminar, in which I enrolled, to his home for dinner. I remember my curiosity as to what his home would be like. I boyishly and presumptively imagined his living room hosting exquisite furniture, his shelf space packed with scholarship, and his walls showcasing fine art and framed accolades. I'm embarrassed to admit that I expected more of an intimidating library than a welcoming home, but my prediction nevertheless proved remarkable inaccurate. In fact, Markel's home highlighted the family man in Dan Markel. Beanbag chairs and other children's furniture lined his living room, toys littered his floor, and drawings and colorings decorated his walls. And whichever shelves were not flooded with coloring books and children's stories, pictures of Markel's family, primarily his children, were proudly displayed. Indeed, the makings of Markel's home broadcasted not only that Markel was a playful, loving, and devoted father, but that fatherhood was by far the most important aspect of his life. Furthermore, through the 2 classes I took with Markel, along with our countless interactions outside of the classroom, Markel and I developed a rather close relationship during my final 2 years of law school. I'm proud to write that Markel became more than my professor. Markel was my friend and mentor, a personal honor. Both then and now, Markel rendered a special interest in me as a student and offered tangible assistance with my aspiring career in criminal defense. The impact that Markel made on me is illuminated through many recollections I have of our relationship, but one final anecdote best encapsulates who Dan Markel was to me. Along my co-author, and while juggling a heavy course load, I worked tirelessly for 3 months, researching, writing, and editing a lengthy legal comment that I hope to publish. Of course, I proudly boasted of the endeavor to Markel, but I maintained serious doubt that the paper would actually materialize into a publishable work. Months after finally completing the paper and soliciting it for publication, a specialty journal emailed me an offer for publication. Reading the offer, which my co-author and I readily accepted, was by far the proudest moment I ever had as a student. And I remember the thought that instantaneously popped into my mind as I exhilaratingly leaped from my chair: I have to tell Markel. Whenever I contemplate what Markel meant to me, I reflect on that moment and how I subsequently darted to campus that day to look for him. He was someone I immensely admired and who I constantly strived to impress. It is for these reasons that I made plans with Markel to keep in touch as my career developed. Tragically, those plans were prematurely taken from our relationship. But what has not been taken is my desire to impress Markel, because I still feel that precise motivation intuitively and as strong as ever before. From that standpoint, I am but one example of how Markel's influence on the world has not lost momentum. No, Dan Markel is not merely a memory. His imprint is here to stay. Oh, my word. Phew, that's so well written as well, hey? Texas B75, thank you so much for your sticker. Let me just go back to it there. My goodness, thank you for your $50 super sticker. That is very sweet. Okay, so now let's see. Sorry, we don't want to take the lunch break banner off. We want to take this and put it here. And let me just make myself bigger for a second while we decide what we're doing next, right? Okay. Southern Calibre says, Grizzly, don't you just love when G reads to us? Is that so? All right, so what's next? Wow, 44% of you voted continue the cross-examination on Charlie Adelson. We started it yesterday in day 7, the lunch break for day 7, right? And you just loved Georgia Kappelman cross-examining Charlie Adelson. And you want to see more of that. 45% have voted that. Jail calls with Donna and Charlie. That would be the one that I referenced yesterday where they're talking smack about Wendi, which is quite interesting as well. Donna's transport video, 19%, okay? And other is 8%. Now, I've missed what the other people said. If you voted other, quickly type in the comments what it is while I bring up what we're going to do for now. Okay, so hold on one second. Somebody's asked, what's written on the wall behind Grizzly? I don't even know. It's a green screen. I have no idea. Do you like my room? Okay, so, ain't no hollaback girl says Charlie and Bree prison call. Okay. Gigi said no more phone calls. Any more wiretaps? Should I put wiretaps as an option? Well, again, the tribe has spoken. You guys do want to hear continue the cross on Charlie Adelson. So I'm going to have to quickly find that. Just hold on one second because it's going to be, wait, maybe I'll find it quicker like this. Wait, let's go like this. Charlie. Should have lined it up, hey? Yeah, nope, that's not the one. We want the full one. That's not the one either. Wait, normally I send these to myself, so I have quick access to them. Hold on. We don't want the highlights. We want the full one. Okay, stand by, everyone. Sorry about this. Charlie Adelson. Cross. Okay, because it's just very intense, right? Okay, there we are. We can pick up right here. Okay, so this was from November 3rd of 2023. I'll put that banner on the screen as well. Oh my, Charlie's so zoomed in now. Stop it, Charlie. Okay, so we'll do it like this. I will link this again below if you want to watch the whole thing, because you can see it's an hour 59 minutes long. Let's go like that. Okay, are we ready? One more time, I just want to check the date. Sorry, my brain did not feel like remembering it. November 3rd of 2023. Okay, Charlie Adelson took the stand just like his mama plans to. Would she not learn from this experience? You really want to take the stand? I think Donna is making some big decisions during lunch today. They should have 2 more witnesses when they come back from lunch, and then Donna will have to decide, is she taking the stand today, tomorrow, anytime, or will the defense rest? That'll be interesting. Okay, so let's continue here.
Private investigator to help you with this whole problem you were having?
With the extortion?
Yes.
No, I didn't tell anybody.
Did you get a bodyguard?
No, I carried a gun on me, and I always sleep with a gun next to me in bed, and I carried a gun on my person and had a gun in my car at all times.
Do you recall a statement you made on the Dolce Vita recording that said you were going to start carrying a gun?
Yeah, because for a long time, after this happened, I was carrying a gun, and it's uncomfortable, and I don't always like carrying a gun. So I hadn't carried a gun in a while, and I was going to start carrying one again.
But you did say in 2016, I'm going to start carrying one.
Yeah, I carried probably for about 4 to 6 months after this happened, and I wear scrubs, so the gun that I had can kind of stick out, and it's uncomfortable. I prefer not to carry a gun.
So you quit carrying it, but during the time you were still paying the extortion money?
Yes.
This is just so brilliant, and also, I'm going to comment on George's choice of pen, right? She's got the best pen choice, in my opinion. I love these pens. These are Pentel Energels, not sponsored. I just love these so much. So she's got the same one there. Also, just some lingering comments from earlier. Ace Bricker said, I got an undergrad and MBA in criminology from the University of Central Florida. I did not have one single professor that I could write these wonderful things about. Wow. Yeah, so these letters were really amazing, right? And Kathleen said earlier, so good to hear these after what we just heard. We needed a palate cleanser of note, like a complete pivot, right, from what we just heard this morning. Yeah, so I'm glad I could read those to you.
All right, and the extortion money that you were paying, $3,000 a month, that wasn't going towards the principal of whatever was left on the $333,000, right? Didn't you testify to that?
Correct.
All right, so you never came up with the remaining bulk of the money that you owed?
Never.
And nobody ever came after you for that?
No, they said you could pay it all off and it'll be done, or just pay $3,000 a month. So I thought about paying the full amount.
All right, then a couple weeks later, after the initial extortion, you and Katherine Magbanua broke up, according to your direct. Do I have that right?
That's not correct.
Oh, when did you break up?
Within a week. I met her, we went out to dinner, I went out to eat, and I just said, this has got to end.
All right, so you broke up with her.
Yes.
Weren't you scared that if you broke up with her that she would sick the Latin Kings on you?
No, because I had every intention of paying every month. When I broke up with her and I said, listen, I don't want to surround myself with this, I'm scared. She said that she was going to come every month and pick up the money and protect me. And she understood. I mean, our relationship was on the rocks.
But you've testified that all the gifts and stuff that you gave her were to keep her happy, right?
Yeah, when I realized that she's the one who's protecting me and she wasn't a part of this extortion, I had no problem keeping her happy, and I looked for things to do, nice things to do for her, because she was broke.
But not worried about pissing her off by breaking up with her.
Well, our relationship was definitely on the rocks. After July 1st, when Sigfredo cut me off and threatened me and called my dad, and then she knew I didn't even invite her to my dad's birthday party, which was a family gathering with family friends on July 5th. She knew we were going to be done.
This is why during Donna Adelson's trial, we've already seen the state shut down this theory. They've already worked very well at it, in some of their direct examination and in some of the cross with the defense's case, because Charlie's story was, which is why I think they won't put him on the stand. Shame, he got transported for nothing, everyone. He got transported and they literally bought him Wendy's for lunch, actually. Wendy's for lunch. Well, that's ironic. You stopped and bought him Wendy's for lunch on his way to Tallahassee to potentially testify for the state, but didn't get called. Probably not going to get called. You're going to be sitting in Tallahassee and then be sent back to South Dakota, I think is where he's in prison, serving a life without parole sentence. But here on the stand, his theory was, and you can see he's quite confident about it. Look at him. Look at his eyebrows. Yes, I was being double extorted. One was by Katherine Magbanua, but I didn't know it because I really loved her at the time. We were in a relationship and then I broke up with her. But she extorted me, and I was also afraid for my life. But then also the undercover cop, he said that was another extortion as well. So, yeah. Was Donna going to have the same approach? I don't think she can now, but you never know.
You broke up with Katherine Magbanua a week after the murder. Did you continue to talk to her?
We still communicated, for sure.
Talk on the phone?
And texted, yeah.
And meet up?
No, the only time I would see her was I saw her again the end of August. She came and picked up the money, and that's when she asked me if I could put her on the books, because none of this money was going to her and she needed to get health insurance for her kids. So I said, yeah, I'll do it and help you out.
And did you continue to hook up with her after the breakup? And by that I mean, have sex with her.
There was one occasion. There was one time that we hooked up.
Okay, when was that?
I want to say it was probably about 5 months after we'd broken up.
Okay, well there was one other occasion before that in October of 2014. Do you recall that? October 9th of 2014?
That's probably the occasion I'm talking about, because July, let me count the months, July, August, September, October, so 4 months. I mean, it's
Okay,
been
and there's
10
another
years.
one on October 15th. You remember that one?
No, I think we did hook up about one time.
And by one, do you mean how many? Because we heard those wiretaps and they were uncomfortable. Okay, we don't want to hear it again. YouTube even age restricted one of the days of the trial where we listened to the wiretaps, which I think was day 5 or 6, because they're like, this is foul. We need to put an 18 plus, like extra layers of protection, because people's ears, they shouldn't hear this. You have to be signed in to be able to hear that crap. Beth Sowell, hope I said okay. You said, why is he in jail in South Dakota, not Florida? Apparently he got threats from the Latin Kings, who of course he threw right under the bus after hiring through Katherine Magbanua, Sigfredo Garcia, the hitman. But the hitman's bestie was a Latin Kings, or is a Latin Kings leader, the guy who snitched, Rivera, right? So yeah, apparently, allegedly, he was getting threats in prison and had to be transferred for his own safety. Something like that. Correct me if I'm wrong, but that's what I've heard, via the grapevine on social media.
Okay, well, one time on October 9th and one time on October 15th.
I thought it was one time. If it was 2 times, it's been.
Could
10
it have
years.
been 2 times?
But no more.
Okay. And on August 25th, 14, that would have been after the breakup, right?
Yeah.
You text her, and then she replies, I don't need help, I'm good. Don't need favors, nor will I trust anyone again. Erase my number, please. Go on with your life like you did already and have been doing. Sorry we spoke today. I don't want to stress your life more. Don't do anything for me. Do you remember receiving that text from Katherine Magbanua?
Yeah, sounds familiar.
And that's a pretty weird text to get from the extortionist. You're meeting her to give her money. Why is she saying erase my number?
She's not the extortionist.
On
In
9/11,
in 2014, I didn't think she was the extortionist.
Yeah, so now he's saying, at this point in 2023, now he believes she was the extortionist. But at the time, he says she's not. So that's why he was, talking to her like that, hooking up with her every now and then.
right, but it's been revealed that she was.
In 2019, so you're taking what was known in 2019 and you're trying to say I knew what I knew in 19.
I'm not trying to say you knew. I'm trying to say she knew. She knew she was the extortionist. Why is she telling you to erase her number and leave her alone?
Because I broke up with her.
Exactly. On 9/11 of 14, she sends you #bestie for life. Do you remember that?
It sounds familiar.
So did you all have some kind of reconciliation after the breakup?
No, I was probably doing a favor and making her happy with something.
On
Probably borrowed some
10/6
money.
of 2014, I love you. It makes me feel good that you care about me. I'm lucky to have you as part of my life. Do you remember sending that to her?
Yeah.
On 10/9 of 14, I mentioned the sex talk. I won't go into the details of it. Again, 10/15, more sex talk. 10/23 of 14, thank you again for everything you're doing for my mommy. She sends you that. What were you doing for her mother?
I don't know. I think I did a consult for her, but I didn't do anything for her mom.
2/24 of 15, you agree that she always knows how to make you smile, and you say I love you to her. Remember that?
Yeah, I cared a lot about Katie, and I didn't think that she was a part of this. So I was always trying to keep her happy and make her happy, and I felt like she got dragged into something that she shouldn't have been dragged into.
Okay.
Oh, so she was dragged into something, but now he says she was actually the extortionist. Right. His theory makes absolutely no sense, and Georgia Kappelman, state prosecutor, makes sure to highlight that for quite some time on this cross-examination, which is just brilliant.
Maybe, but she dragged you into it as well.
I didn't see it like that at all. And our relationship actually got stronger. Initially when I got extorted, I had limited contact with her and I was cold to her. And then over time, I realized that she's the one who's protecting me and she's not involved with these people because the extortion never went up, and Katie was always broke.
She was involved with them because she had a child with the guy, right?
I didn't know for sure it was him,
but you suspected always that it was him.
I always suspected that Sigfredo was behind this.
So wouldn't you want to distance yourself from this woman who, I mean, were you ever really that serious about her to begin with?
I mean, we spent 7-8 months together.
But you were never considering marrying her.
No, I wasn't considering that.
I mean, you were a playboy, right? You had a zillion girlfriends.
That is actually not even true.
Okay. Did you have a lot of girlfriends?
I had 2 girlfriends in the 2 or 3 years after her. I dated Whitney Kick for 9 months.
Okay, but how many women were you talking to and engaging with sexually? A lot more than Whitney Kick, right?
There could have been 1 or 2.
Or more?
No.
Okay. Point being, you...
Why does he want to dispute that? No, wasn't. Yeah, you were. I know I wasn't. Don't say that in front of my mother might be listening.
We're not going to marry Katherine Magbanua.
I wasn't having marriage plans, no.
Okay. And you have now broken up with her after this incident.
Yes.
She's the person that's taking the money from you physically.
She's the one. I looked at it as she's the one who's protecting me. If she wasn't, I was going to get a visit from somebody.
Is she the one that was physically taking the money?
Yes.
Is she the one that was connected to the person you suspected to have killed your brother-in-law?
I thought she was tied to that person, yes.
And she's the one that got you into this, right? Because she ran her mouth, right?
And I looked at that I ran my mouth too. And if I never said anything to her, this would never have happened. So I felt responsible for saying something to her in the first place.
But you didn't feel responsible enough to try to do anything about her sitting in jail, an innocent woman, for 3 years. Did you?
She never contacted me.
You didn't offer to testify in her trial. You let her get convicted and get life in prison, didn't you?
I thought the truth was going to come out.
But not through you.
I was never contacted. I thought it was going to come out through her.
Was there any contact between your lawyers and her lawyers?
You'd have to ask them.
You said you didn't have any contact with her. Did you have any contact?
I had 0 contact with her.
So your lawyers didn't tell you anything on behalf of her lawyers?
Absolutely not.
And her lawyers didn't hear anything from your lawyers?
I don't know what lawyers talk about, but I can tell you that I never talked to Katie, and I never told my lawyers.
You never relayed a message through your lawyers that the Adelson family would not be talking in this case?
Absolutely not.
And she had nothing to worry about as far as that end was concerned?
That's not true at all.
Did you or your agent contact her brother to offer to assist with her attorney's fees in her case?
That's a complete lie.
On 10/27 of 15, you say you can't wait to get lunch with her. She's the best, and you're lucky to have her as a friend for life. Did you say that?
Yes.
10/27/15, you can't wait to get lunch with her. 10/30/15, you tell her you miss her. 12/9 of 15, again you tell her she's the best.
Yeah, I said all those things.
Do you agree that this picture does not look like a relationship between an extortionist and her victim?
I agree, because Katie wasn't the extortionist.
She was.
Except in 2023, he's saying she was.
Was the extortionist.
In 2014 and
No.
2015, I didn't believe that.
I know you didn't believe it, but we're looking back now, okay?
You know, it's like if you're going to quote me, date me. Like, at what I knew in 2014 and what I knew in 2015 is not what I know now in 2023.
Okay, yes, I hear you. You didn't know then, and that's why you were nice to her.
Yeah, I thought she was protecting me.
Got it. And none of those factors that I pointed out weighed into that consideration. That she ran her mouth, that she brought the Latin Kings on you, she was taking the money from you. None of that counterbalanced it. You were still going to be friends with her and keep her happy.
You're wrong. I didn't know about the Latin Kings in 2014 or 2015.
All right. The love text, which is what I'm referring to all these texts, where you're still nice to this person after you break up with her. You're still doing favors for this person after you break up with her. I mean, that's like a major problem for your defense, isn't it?
No, our relationship got stronger. I agree. Our relationship got stronger, but it was much different.
Isn't that why she has to be an innocent conduit between you and the bad guys? Because if those texts didn't exist, she would be the extortionist and the bad actor in this whole thing, right?
I'm not following your theory.
You have to explain away those texts, don't you, Doctor?
No, I have to sit here and tell you the truth. And now you're finding it out.
Damn, he's got attitude, huh? He claps back, which is very silly of him. Don't clap back at Georgia. I want to see Donna on the stand, and I want to see cross-examination from Georgia Kappelman, please. We want to see that. And what story is she going to sell, huh? With a little cardigan on and everything. Sweet, sweet granny. Had no idea that my son was caught up in all of this, huh? That's probably what it's going to be, huh? Throw Charlie under the bus. Okay.
Most people don't send kissy faces to people that are extorting money out of them. I mean, she was taking your money.
Again, Ms. Kappelman, she was not extorting me at the time.
That's not how it's done, is it?
I'm telling you how it was done.
So then over these next 2 years, you would meet her monthly and hand over a bundle of checks and $3,000 in cash, right?
No, you're wrong.
Okay, tell me.
I would hand over $2,000 in cash and a bundle of checks.
$2,000 in cash and a bundle of checks.
As if
And
that
so
makes it better.
over the course of 2 years, I'm terrible at math, but that's roughly how much money? Because I think I did $3,000. It's $48,000 in cash, in addition to the $138 you provided the night of. Do you agree with that?
If your math is correct, I'm just telling you what I paid her each month.
And the checks, which is another $17,000, right?
You're doing the math.
Okay. It was a lot of money. Was it a lot of money to you?
It was a lot of money to me, yeah. I work hard.
We heard how hard you work while you're on the phone to Katie. We heard those wiretaps. Oh no, we never want to hear them again. Still washing out my ears. How about you? Oh my word. So working hard, patience in the room, flirting with Katherine Magbanua. I'm saying flirting to be polite. It was much dirtier than that. Okay, working so hard.
Did the extortionists, whoever they were, ever try to increase the payments or come for more money?
The extortion never went up, and Katie was always broke. And that's what led me to think that she was not a part of this, because she could have easily jacked up the payments.
Well, she's sharing $3,000 a month with a bunch of other people, right? At least one other person.
I didn't think she was sharing it. Why is she coming to me for $300 for her kid's birthday?
Because she's broke.
Because she wasn't getting any of the money.
Half of $3,000 doesn't do much when you're living in Miami with 2 kids to feed, right?
I didn't think she was sharing anything.
Well, even if she was sharing it, that's your point. She must not have been taking the money because she was broke. And my point is, she could have been taking half the money and been broke.
That's not how I saw it.
It's not a lot of money.
That's not how I saw it.
Tell me about...
You know what's a scary thought? Imagine if it was, and I'm not doubting the ability of all other prosecutors, but imagine if it was anyone else on the case. It just wouldn't be the same. Would they be prosecuted the same? Would they be arrested the same? What would happen in this case? I have full faith in Georgia Kappelman and her team, right? Sometimes one has an intrusive, scary thought like, oh, imagine if she was not the one doing this cross-examination, because it's so well done, right?
About Dan Markel a little bit. What you sort of said, what I heard, correct me if I'm wrong, was he was, a nice enough guy, typical Wendi boyfriend, but not really your kind of guy.
Yeah, I think it's an accurate description.
All right. Do you agree that he was this brilliant legal mind?
I think he was a little on the nerdy, nice guy. Just kind of like the average guy that my sister dated.
Not the kind of guy you want to have a beer with, though.
We never had a beer together. I mean, not that I wouldn't have had a beer if he wanted to have one. We just didn't have that much in common, but he was always nice to me.
Do you appreciate the fact that his death was a terrible loss to his sons?
It was horrible.
Do you think they were better off without him?
Absolutely not.
Did you host a celebration dinner after his murder?
That's a complete lie.
On The Wire, would you agree that the Markel boys were in the background pretty much of every call you had with your mom? I mean, we hear them a lot, right?
My sister was working, so my parents would help my sister out, yeah.
Yeah, and it was summertime, so they were out of school, I would assume.
I don't know if it was every call, but they definitely helped my sister out for sure.
All right, and those calls captured Donna pushing them on the swings, that call that tortured all of us a couple times. Remember that one?
Georgia says that tortured us a couple of times. We remember it. If you were there during that day of the 8 hours of wiretap calls. Oh, you heard it. The swings whistling in the background. Chris, welcome to Grizzly Supporter. Thank you for being a member. Harry says, gee, we couldn't have lunch without you. I really appreciate you all being here having lunch with me. As we watch this, you can see the time that the court will be back. As soon as they're back, we're switching over back to the courtroom. Let's just quickly look at the time. Local time, if you're watching live with me, is 9 minutes to 2. So we have less than half an hour left. Charlie, give us your best shot.
Yeah, there was a call where she was pushing them on the swings.
Taking them to tennis lessons.
On the stand. Now I'm going to snark at myself. Not an appropriate phrase, given the case. Sorry about that. Didn't mean it. I just mean Charlie, really. Try your best to lie your ass off. And his mommy, Donna, in jail calls said, but you did so well, Charlie. You did so well on the stand. Everybody knows it. Your attorney said it. Everybody said it. He's like, I know. Can't believe they convicted me. I mean, he was so swiftly convicted. I think they came back within like 3 hours, right? And it included lunch or something. They came back quick. I wonder if Donna's convicted. I wonder how long the jury will deliberate.
That was the same day. I mean, that was the same call that got broken up, and she called me back. But yes,
doing their bedtime routine,
helping my sister out for sure.
Reading stories, brushing teeth, getting haircuts, going to piano, story time and bedtime, all of that kind of stuff.
Yeah. All stuff that parents and grandparents do. You're right.
All right. She even said to you on one of the calls regarding the bedtime routine that, quote, we have a whole routine going. Do you remember that?
I have a whole routine with my son. I mean, I think it's normal with kids. You have a routine to put them to bed.
Right.
Do you have a whole routine with your son? He has a son, by the way, who initially he denied was even his, to the point where the mom had to file things in court to get him to admit that he owed child support, that he was the dad, all of that, right?
You gotta brush your teeth. Can't forget to brush your teeth.
Yeah. Little dental humor couldn't hurt, right?
What's that?
All the things that you know your mom wouldn't have been able to do as readily if the kids were living in Tallahassee. Agree with that?
I mean, when they come up to visit them, they'd be doing the same thing.
Sure, when they came up to visit, but now they're doing it every day, right? Almost every day.
Not every day, but when my sister needed them, she helped them out.
And
Did you hear that? He's like, can't forget to brush your teeth. And Georgia's like, little dental humor can't hurt, right? And he's like, sorry, what was that? And then she just moved on. Wow.
They're all things, these little routine things that Dan Markel will never be able to do with his sons. Do you agree with that?
Absolutely.
Does your mom have a favorite child?
She says she doesn't have favorites, but I don't think she likes my older brother.
Okay. But is Wendi the favorite?
I'd like to think it's a tie between me and her.
Does your mom...
Oh, don't worry. Charlie, you and your mom have a lot in common. You know, both wanted to go to Vietnam. Both arrested. You LWOPed. Maybe she'll be twinning with you soon. You're definitely the favorite. Look at him. He's so impressed with himself. Wow. Okay.
Worry more about Wendi than you? Let's do before this case.
No, I don't. I mean, I don't. I think maybe in different parts of my life, she's probably more concerned about me. Different parts of my sister's life, she may be more concerned about her.
Is it true that your mom has a tendency to worry herself sick if there's something going on with one of you kids?
No, I mean, she's a concerned mom, but I think she's a normal mom.
Was she pretty worried about Wendy's marital problems?
No.
She wasn't?
I think No, I think she'd get upset when my sister would tell her things that Danny was doing and going to work, bad-mouthing her, but I think any parent would get upset.
But also she would meticulously go through all the filings and send long emails detailing her thoughts about every filing in this divorce.
No, I don't think that's the case at all.
Okay.
Oh, so just disregard the emails. Kathleen said, Robert is our favorite. I agree. Robert is our favorite. Yeah. Robert is Dr. Robert Adelson, the eldest son of Donna and Harvey's, right? The estranged son who testified, yeah, for the state. That was brilliant. So, wish I could interview him a little bit. Hey?
Did she hate Dan Markel?
I think she liked him in the beginning, for sure. And I think when he was being a jerk to my sister, I don't think anyone particularly liked him when he was being a jerk.
What about the time around the time that he was killed? Did your mother hate Dan Markel?
No, I think it had kind of like tapered off. I think she only disliked him when he was being mean to my sister. Other than that, nobody had a problem with him.
He was being mean to your sister during these divorce proceedings and subsequent litigation, right?
I think it was on and off. I think it was sporadic.
And when your mom's worried about Wendi, does she come to you for solutions or to talk things out?
No, I don't think worried is the right word to describe it.
Does she ever make Wendy's problems your problems?
No.
Like convincing you to get Wendi to pull the plug on the house on Halloween 2013? Didn't she convince you to sort of take up that cause?
No, that was actually me. I thought I shared my thoughts on home ownership from my sister. That was all me.
Didn't you say that if she had bought that house, that would have been the second worst decision of Wendy's life?
I thought it was going to be a stupid decision to buy that house.
And what was the first worst decision of Wendy's life?
Oh, I thought looking at hindsight 2020, I think when she'd agreed when she married Dan.
And did you convince her to take a particular job as well? Remember that call?
Yeah, she got an offer from a law firm, and she was debating whether or not she should take it. She didn't know if it was exactly what she wanted to do. And I was like, hey, you don't know what you don't like doing until you've done it. Seems like a great opportunity. Like, why not do it? Learn the job skill. It's a skill you don't. And she's like, well, I don't have that skill. And I'm like, well, it's a good opportunity to learn it, and you may like it. And if you don't like it, then try something else. But I was trying to encourage her to take what sounded like a great opportunity.
And Mom shared your thoughts, and I'm referring to Donna Adelson, shared your thoughts about this opportunity being a good one for Wendi, right?
I probably heard about the job from my mom, but I definitely heard about it from my sister because I'm talking to my sister about it.
Yeah, I mean, the job...
Brother of the Year got L-whopped. I'm sure everyone's so happy they took your advice. Hey, Charlie?
Job was not what she had any experience in, right? It was a whole nother field of law.
Then that was my point. It was like, well, why not take it if they're offering it to you and you can learn something new? It sounds like a great opportunity.
Do you and Donna know what's best for Wendi better than she knows herself?
No, but not at all.
Were you a spy when it came to Wendi? Did you get information from from Wendi and relay it to Donna?
At times, because I was dating Bree, and Bree worked for Dave, so I would hear stuff about Dave from Bree, so I kind of had an inside. I got inside information.
In what capacity did Bree work for Dave?
Dave was his. After she graduated from college, she was working as a nanny for Dave.
All right. And how old was Bree during the time you were dating her? Was she significantly younger than you?
She was 24, and I was 39.
Is Bree the mother of your child?
She is the mother of my child, yeah.
All right, so back to Wendi and Donna. So Wendi, was she tight-lipped with Donna about her private life?
I don't think she shared everything.
But she would tell things to you that she wouldn't tell to Donna.
I can't say that for sure.
Can you play clip 1, please? Publishing call EEE.
Yeah. Oh no. I was like yes, but no. Maybe I shouldn't get excited about what they're going to play. Oh, we're going to hear it again. Oh no. Just for those only joining now, if you're just peeking in, seeing what's going on over here, This is the spicy lunch break, as we call it here, the full fluff buffet, meaning we're spending the lunch hour together. It's actually quite a long lunch break today, but guess what? In 20 minutes, they're back. So they're back at 2:20 Eastern time if you're watching live with me. That's local time there in Tallahassee, Florida. And what we're watching during today's lunch break is actually a continuation from what we watched in day 7's lunch break, which is Charlie Adelson's cross-examination, because the dumbass decided to take the stand and give out a whole theory about how he was the victim of double extortion. So Georgia Kappelman, she did the cross-examination brilliantly, as we can see, on November 3rd of 2023. By November 6th, Charlie was convicted, and then by November 13th, Donna Adelson was heading out. She was going to Vietnam. She's like, I'm out of here. And she was arrested at the airport. So yeah, now she's on trial. So thank you for being here. Let's continue to watch a bit more of this.
E. 3 E's.
There's Dan Rashbaum, who was Charlie Adelson's attorney, who Donna really wanted as an attorney, but couldn't have. She did have him initially, but couldn't have because of a conflict of interest.
Which way are you going? I'm this way. Just stop off at there and fast. Anyway, so I just put the date now.
Oh, did you?
So I just called him an old fart. And she's a few months older than me. But so I asked him for his birthday. It turns out Wendy's making him a little party in Fleetwood.
Oh, really?
Yeah, Wendy goes like very tight-lipped.
You're not kidding.
So what you need to do is, she's obviously tight-lipped for a reason. It's because she doesn't want you to know anything.
Anything.
So my point is, if she doesn't want you to know anything, then don't ask anything.
I don't
She'll
know.
be happy.
Yeah.
And then I can find everything out and just tell you.
I know. It's great.
He loves conversations with his mom. Look how he smiles. Obviously, he'd love his mom, you know what I mean? I'm just saying, the two of them, damn. As they say in South Africa, in Afrikaans, swart soek swart, which means birds of a feather, hey? I mean, Charlie said, she doesn't like my older brother. Dr. Robert Adelson's estranged from the family. He must be very, very happy about that, especially now, right? And then she loves Charlie, hates Dan Markel. Yeah, Donna, birds of a feather. And now you're both going to have timeshare in prison. So yeah, but he loves these. He loves reflecting on these. You could see it on his face.
So I was like, so what are you doing for your birthday? It's like, well, Wendy's making me like a little birthday dinner, a little get-together party. I'm like, that's awesome. He's like, yeah, she's doing it. He's like, I don't know anything. All I know is Wendy's putting it together for me, and she's doing it in Woodwood.
Aww.
So I'm like, oh, that sounds awesome.
All I knew is that she was going straight from work to the hotel where everybody is meeting for the this Miami Fellows thing that she got, and that she was going to be there tonight because it starts early, first thing tomorrow morning.
Right.
I guess in between, she managed to do something else, which makes me happy. I'm really glad.
Oh, yeah.
I couldn't imagine. Oh.
Yeah,
Yeah, he sounded good.
Yeah.
Yeah.
Do you remember yesterday, since you were telling a story about Katie coming in from having had some kind of altercation with Garcia, and she had reported that the necklace had been pulled off her neck. Do you remember that?
Yes, I do.
All right.
Sorry, I'm laughing at the courtroom coffer. There's always one courtroom coffer. One of them arrived in Donna Adelson's trial today. Somebody was coughing it up there. We just heard the courtroom coffer here. Woestyn Blom sê die appel het nie ver van die boom afgeval nie. En Gerda says hierdie appeltjie val nie ver van die boom af nie. So the apple doesn't fall far from the tree. Exactly.
When you were relaying that story to the jury, you used a specific term describing what Garcia had done to her. Do you remember what that term was?
It was only yesterday, but you'll have to refresh my memory how I described it.
You said he roughed her up.
That's accurate.
And that put my antenna up, because that roughed them up is the exact same phrase that Katherine Magbanua said in her proffer that you used on Halloween 2013 when you first approached her about, does she know anyone who can rough someone up?
No, I think getting roughed up is an adjective, but what you're doing is the same thing you did with your TV theory. Is like you heard TV mentioned multiple times, so you put the whole case together with the TV.
Okay,
and
we'll
you're putting
get to
the whole
TV.
case together with the word roughed up. Like,
Yeah, I mean,
Oh my word, he's so stupid. He's just clapping back left and right with attitude. He really thought it's going to go well. Like, I'm just going to get up there and just save my own ass. Yeah, and then you got Al whopped. Don't worry, I've got 3 screens, right? So I'm monitoring the live court feed when they're back, which they said counsel must be back at 2:20 Eastern. They're going to resume at 2:20 p.m. Eastern. We're going to switch over, okay, to the court feed. So don't worry. I am monitoring for us.
Not putting the whole case together.
One moment. Don't speak over each other.
But that's
Please wait for him to answer, then you can ask your next question. Go ahead.
But that's an unusual, I mean, it's a specific term. I'm not making a whole case out of it, but did you say roughed up in both places?
Katie was roughed up by Sigfredo when he tore the necklace off of her neck, yes.
And isn't that the same term you used when you first broached Katherine Magbanua about did she know someone who could rough up someone else?
Never in my life have I ever asked her that question. Never in my life. That conversation never took place.
Did you ever hear Donna Adelson refer to Dan Markel as stupid?
No.
Were you laughing when Wendi was on the stand and I read all the names that Donna referred to Dan Markel as?
No, I laughed when you said the word fucker in court.
Okay. What did she mean when she said Dan Markel was trying to take her sunshines away? Do you know?
My mom never said that.
Oh, so you never heard her say that?
That was made up, and he put it in a court filing, and then now it becomes something that my mom said because someone made it up and put it in a court filing. My mom never said that.
Did your mom refer to the children as her sunshines?
No, the kids were 3 and 4. A 3 and 4-year-old can't repeat a conversation and remember.
That wasn't the question. Donna referred to her jail daughter as her sunshine. Donna referred to Wendi as her sunshine. There's pictures floating around out there of, pictures of Wendi when she was younger, in high school and throughout her life. And Donna has a little quote there that says, "You are the sunshine of our life." It's standard. She says it. She does it. So yes, of course she said it about the grandkids she was so obsessed with that she allegedly had a man murdered over it, their own dad. You know what I mean? But Charlie's like, not at all, never. They would never,
Words 6 hours later and repeat it accurately. I have a 5-year-old son. Never seen a 3 and 4-year-old do that. So it was made up, and now you're repeating it.
Okay. Have you been a good brother to Wendi?
I've always tried to be a good brother.
It sounds like maybe you're not agreeing that this was a really nasty divorce, or are you agreeing it was a nasty divorce?
I mean, I don't think any divorces can be pleasant, but I think they definitely had their fights. I mean, they were fighting over bicycles and all kinds of crap.
See,
but in addition,
put Charlie on the stand at Donna's trial, because those 2 attorneys from today, they never said that they were fighting over bicycles and all sorts of crap. They said it was completely amicable, not contentious.
To that, Dan Markel accused your sister of fraud, right?
He made an accusation, yeah.
Threatened her with federal kidnapping charges.
Oh, that's a new one. You just told me.
That one's in the emails that are in evidence. Did you review those?
I didn't review the federal kidnapping charges in this case.
Was seeking contempt proceedings. You heard about that here in court, yes?
I heard about that, yeah.
Even went after her lawyer personally, right?
He made serious threats against her lawyer.
And her bar card could have been in jeopardy if any of those, or some of them.
I heard the other day she was saying that, I guess he was threatening her lawyer's bar card.
Her lawyer's bar card as well as Wendy's.
He was making lots of threats and writing lots of stuff, I guess.
And he messed with your mom too, didn't he, in that grandma motion? You know which one I'm talking about?
I don't think he was messing with my mom. I mean, nobody took that seriously, and I don't think anyone even knew about it.
Isn't your mom... I'm sorry, finish.
I said I don't think anyone even knew about it till years later.
Isn't your mom notorious for always getting worked up about everything?
She gets upset. I mean, she's a concerned mom. I mean...
But is she notorious for getting really worked up about everything?
To a certain extent. I mean,
aren't those your own words from Call S that's in evidence in this case?
Yeah, those are my words, but you can't, not to an extreme, but she does worry, especially when like Latin King gang members are extorting her for money.
He's very confident, huh? On the stand. And you know, it only takes one juror, so I'm really glad that the jury was able to see through this, because he's like completely overconfident on the stand. Look at him go. Clapping back, holding his own, speaking so well, as his mom said. Nonnie Ann said, I have a 3-year-old niece, she will repeat everything. Not according to Charlie. Okay, and Charlie knows things. He's a great dad. Did
your mom take the grandma motion seriously?
I don't think she even knew about it.
She didn't talk to you about it?
No, I didn't find out about it till years later.
Wasn't this divorce a big deal in your family?
It didn't affect my life, I can tell you that. So I don't think that's true. I think it was a big deal in my sister's life.
Why did Wendi testify that she was getting along well with Dan Markel just prior to his death? Can we agree that's not true?
I think there were ups and downs in how they got along. I mean, you got to ask her. She was on the stand. I mean, I wasn't living her life.
Is it part of your defense to minimize how nasty and contentious this divorce was?
No, my defense is to tell the truth.
Did you have any input on the decision to change the boys' names from Markel to Adelson?
Absolutely not.
Do you and Donna have to protect Wendi?
No.
Does Wendi appreciate everything you and Donna do for her?
You got to ask her. I mean, she's my sister. I love her. I try to give her my best advice I can. And if I care about her, and I give her my advice, whether she takes it or not, is up to her. She's a grown woman.
Let me ask it another way. Do you feel, or isn't it true that you don't feel that Wendi appreciates everything you and Donna do for her?
My sister had no idea what I've been through in the last God knows how many years, and what I wake up worrying, am I going to get killed? Am I going to get arrested? And she knows none of it. She's just going around her life, and I had somewhat of an innate anger towards.
Oh, look at him, still protecting Wendi. He's like, she's a grown woman, but are you a grown boy? Stefan said, which truth, the one from 2014 or 2023? Not that Mickey said, I bet most jurors know someone who has gone through a divorce. The contentiousness is in the eyes of the parties. Jurors won't appreciate that, right? Thank you so much.
Her, probably unjust because she didn't know what happened. But yeah, I was upset.
And weren't you saying on the wire that she doesn't appreciate what you and Donna have done for her?
I don't know if I said that she doesn't appreciate what I've done for her, because I never did anything for her.
Okay, so that was my next question. What have you done for her? Nothing?
Other than give her advice and care about her, be a big brother that loves her.
Would you say Wendy's a little bit spoiled?
I know he's older than Wendi because he's the middle child, but big brother that loves her. She does have an elder brother, You have a big brother too, Charlie. Which is Rob.
In some regards, I mean, she gets a lot of help, for sure.
Is she a little less savvy about how the world works than you are?
I don't know. You got to ask her.
Could you trust Wendi with a secret that could ruin your life?
It's not a secret. It's something that would get me killed, so I didn't want to tell her.
Can we agree that she obviously knew something about this crime?
She found out when she came to court. I never told her anything.
I'm talking about the murder of Dan Markel. She knew something, right? I mean, it's not a coincidence she went to the crime scene, is it?
You're talking about the route that she took that day?
I'm talking about her pulling up to the crime scene tape.
She never went to the crime scene. She was going to buy a bottle of liquor that coincidentally the person sent her a stock the bar party buy a bottle of bullet bourbon that she was going to pick up. She wasn't driving to a crime scene. And I think
I'm only laughing because of the way he said buy a bottle. His cheeks went like buy a bottle of bullet bourbon. Okay, say it faster. 7 times. Charlie, say it faster. Bottle of okay.
She made that clear too. Nobody knew a murder was taking place.
She pulled up to the crime scene tape, Dr. Adelson.
She didn't pull up to the crime scene tape. She was driving down the street and then had to make a U-turn. It was blocked off.
How do you know?
But she wasn't going to.
She couldn't help herself. Isn't
Nobody
it?
knew a murder was going to take place.
But
She exposed you all to some degree by those actions, didn't she?
No, not at all.
And then she threw you under the bus in her interview, didn't she?
Nobody knew a murder was going to take place.
She did.
She knew her husband had just been shot, and they were asking her who would want him dead, and she said your name. Are you mad about that?
No, she said a lot of people's names.
Well, she
Not at
said
all.
yours in the first 25 pages of a 5-hour interview. Isn't that true?
I
How about now that you've been L-warped?
wasn't there for the interview.
But you've reviewed it in preparation for your trial, haven't you?
I actually don't know if I've seen her interview.
There was a lot of questions of you about, didn't you do this murder with Wendi? Doesn't the state think you did this murder with Wendi? Are you familiar with your charges in this case?
Yes, I'm very familiar with my
All right.
charges.
And who are you alleged to have done this murder with?
I'm alleged to have done this murder with my sister, my mom, and my dad.
Would it refresh your recollection to review a copy of the indictment in this case?
I'm a slow reader, but I could read it if you want.
May I approach, Your Honor?
Okay.
And this is the official charging document in your case, Dr. Adelson. What does it say in reference to who you are alleged to have committed the murder with?
This is, what date is this? 2022. Oh, they think I did a murder with Katie.
Katherine Magbanua.
Yes.
Anybody else?
Give me a minute, I'll read.
But interesting how you said my mom, my dad, and my sister. Yeah, you didn't want to say Katherine Magbanua, Sigfredo, Garcia, and Luis Rivera.
They got Luis Rivera in here. They got Sigfredo Garcia.
As being alleged to have committed the murder with you?
Did I read it too quick?
Take your time. Should just be at the very top of each charge. On or about July 18th, 2014.
At the tippy top.
Did unlawfully.
Okay. Yeah, Katie. Katherine.
Okay.
Perfect breaking point. Here comes the judge for the live court feed. Are you ready? Ready to switch over, everyone? Thank you for spending lunch with me. I will link that full testimony in the description box below, in case you want to watch that.
First, concerning the waiver of attorney-client privilege.
Okay, wait. We want to hear all that. So, first we'll put our... Let's make sure this is like this. I just want to see, because one feed is a little better than the other. Stand by. Tammy, thank you for your sticker. Okay, I'm going to play this one for now. It's fine. This one is ahead of the other one. Okay, Sound is on. There they come back. Hold on. I want to switch to the other feed. Wait, Judge. Shh. Sorry, everyone. I want to make sure you have the best viewing experience with the best sound as well that I can possibly give you. Okay.
All right, 2 matters to briefly address before we bring the jurors on. The first concerning the waiver of attorney-client privilege as to the testimony of Ms. Descalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further calls with?
Yes, Your Honor. The waiver is specific as to the counsel that our client received from Ms. Descalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf.
So Donna is pretending she can't hear and needs everything told to her now? Let's quickly boost it while we're here. Wait. Donna, get on the stand. Now she's got a hair clippy. She's dropped the scrunchie, probably because we've said it so many times.
Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that was discussed after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope.
So she is agreeing to a waiver of attorney-client privilege, meaning the next witness. So she's not going to be on the stand yet. Will she take the stand there? Okay, the next witness is probably going to be her attorney, right? She waives the attorney-client privilege. Correct me, lawyers, if I'm wrong. This is what I'm understanding. And so the next person, oh, you're going to spill some tea, and she agrees to it. Okay, cool. Tell us everything.
At that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
Yes, sir.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her?
Tell us.
As to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I have discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced at this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Judge, please take the reins. Deny this crap. I mean, hello, this is a trial. Donna Adelson is on trial. They indicated before the trial started that they want her, well, she wants to take the stand. And now you want to go through what? How long is that going to take? Months? All of the evidence? What?
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what is actually coming in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know that we will get started momentarily. Okay.
Ooh, the judge is not impressed. You will have 5 minutes to decide. Like, what is this bull crap? She doesn't know yet, Judge. She doesn't know yet. Donna, time to make a decision. Sounds like you've been accused of making some big decisions. That's why you're here, right? Okay, so Donna now has waived her attorney-client privilege, so at least we'll see one of her former attorneys on the stand. Okay, and see what they've got to say. And also, Donna is undecided if she will testify or not. Okay, we've refreshed the feed here. 1 more second, let me do it again. They won't be long. How do I know? I can see it on the other feed. They're like 2 minutes ahead, but we're gonna wait on this one because this one has great sound. Even though it's the same courtroom feed, I just find this one has great sound, okay, in this trial. Yeah, Lucy's World, you got 5 minutes to figure it out. I mean, yeah, we do probably need a poll. Hold on 1 second. Let's vote, everyone. Do you think Donna will take the stand or not? Don't answer yet. Don't answer yet. I'm going to make you a poll to vote on. Do you think?
Is the response from the audience concerning things that are said by the defense. And although the proceedings are public, that has not stopped Peanut Gallery from their comments and laughter.
Peanut Gallery.
We are respectfully requesting that the court allow Ms. Adelson to participate at sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
Please approach.
That was a nice and carefully worded New request for the same crap. We need more time because Donna can't decide, okay? She's just not sure if she's going to sink herself or not. She's gonna. She's too scared of Georgia Kappelman. We want to know who's going, even though both attorneys are excellent, both prosecutors are so good at their job, right? But I could just imagine them. We want to know which one of them is going to do the cross-examination.
We're not going to do this for very long.
We're eye-rolling in silence now. Right. Now we have to wait for the sidebar to finish here. Wow. Will she take the stand or not? That's the question on the poll. Do you think Donna will take the stand? Hey, I wrote O with a capital. I mean do, Donna. Do, will she? Just do it, Donna. Anyway, so yes says 46%. No says 54%. If I were her, I wouldn't. Don't even try. Georgia's coming for you. But for our purposes here, I would like to see her take the stand. I want to see that acting. In the performance of a lifetime. As those are her words, she said to Wendi, right? You now have to do the performance of a lifetime. Yeah, Donna, it's your turn now. She's busy choking. Choke, Donna. Come on, get on the stand. Stefan said, Donna, you'll get LWOP in both ways anyway. But she's undecided if she will or won't, though. She thinks it'll make a difference, okay? Could she convince the jury or not? It's also interesting to hear the defense, you know, they're so nervous about all the evidence. Interesting. that they know she'll be cross-examined on. And now we wait. Someone says she wants the room cleared. Shell Bell, she wants the room cleared. Defense attorneys, Judge, please, we need more time. We need at least 10 days. We said that, actually, the defense said that they need 4 to 6 days to present their case. Did they mean that day 1 and 2 is witnesses, and then day 3, 4, and 5 would be Donna deciding, and then day 6 she'll take the stand? Yeah, Pernell says, go on, Donna, get your 15 minutes in. Teresa said, narcissist almost always gets on the stand. I don't think you're wrong. Yeah, we saw many of them, hey? Aliyah Bulaban, Nicholas Casodis. Which others can we think of that took the stand? Trying to think of that one's name. That was a crazy case. Hold on. The one who buried her husband in the backyard? That one took the stand. Do you remember that? Camera person, we like to see what they're doing. Can you show us again? Hey, Sugar, it's they are letting her lawyer influence her? Virginia Suchland says they're just stalling. Gink Girl said, lol, this judge doesn't play 5 whole minutes. I mean, the judge specifically said that today's lunch would be 15 minutes longer so that they could give Donna that extra time to make sure that she could decide, are you testifying or not? Yes. Yes, Stefan, you mean the patio? That one. What was her name again? Oh, my word, yeah, Sarah Boone. I did not cover that trial. But still, yes. Alec Murdaugh took the stand. Sarah Boone, yes. So many of them. Whittaloo says, I agree she'd be insane to take the stand. Georgia will eat her up and spit her out. That's why we want her to, right? Please take it. Please take it. I mean, Donna is saying she's hard of hearing, so is she plugged into some sort of system there? Sidebar. Do they have a sidebar system? Because she took a little $2 earphones with her. She should have taken the other ones and flipped them around, right? True to form. Mom Against Crime said, take the stand. Georgia wants her dessert. Okay, let's see how the poll's doing. Do you think Donna will take, oh, I even wrote, do you think Donna will take the stand? So you can see I wrote that poll real quick. 47% say yes, 53% say no. If you haven't voted yet, let's see, many of you have not voted yet, then you are perched on the fence with me. We're just looking at the others voting. But try to vote if you can. But I'm like, I don't know, man. Will she take the stand? I'm not decided. I'm not sure. I think she shouldn't, but I want her to. Havilo never answered. Do you think she'll be found innocent if she does not take the stand? Hell no. Absolutely not. Ah, yes, Lori Shaver. That was the name of the creature who buried her husband in the backyard, which she called a patio, all of that. She took the stand. If you did not watch the Lori Shaver trial, the replays are always there for you. That'll be homework after this trial, because holy crap, you want to see someone lie on the stand? Blame her own daughter? Just say all sorts of crap? Wow. That one is one to watch. Copper Horse said, Donna doesn't realize that even her lies won't save her. Jurors are so smart, right? Doro Teagana, I always want to say you guys' names right. You said, I think Donna will make the reasonable choice and won't testify. I think she shouldn't. But will her attorneys advise her to or not? Yes, Nana Junkin said Gisela, Lori Shaver, and blamed on her 4-year-old daughter. That case was so crazy. Juliet's Moment said, I myself believe it's going to be a hung jury. Well, I damn well hope not. Thank you so much, Juliet's Moments, for being a member for 5 months. Are we there yet? The sidebar happening. I hear sound. They're coming back. Jury's coming in. And what's the decision, Judge? What's the decision? Oh no, they're gonna have more time. What I will guess, because now we're not hearing what the update is that maybe the agreement is let this witness testify, and while this witness testifies, let Donna think about it. And at the next coffee break, we'll ask our client, we'll ask her, okay, just let these witnesses go for, there's 2 more witnesses before that even has to happen. That could be the logical agreement of whether she's going to testify or not.
Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
No, Your Honor.
Defense 50 is admitted.
Thank you. At this point in time, the defense would call Marissel Descalzo.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marissel Descalzo. My last name is spelled D-E-S-C-A-L-Z-O.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son, Charlie Adelson, was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting as putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
Just to clarify, the decision about whether or not Donna Adelson will testify has has not been reached yet. So we can only assume the judge has given the defense a little bit more time, and by that I would plausibly speculate, meaning let these next two witnesses take the stand, maybe they have a coffee break, and by then she will have to say, right?
Nothing further, Your Honor?
Cross-examination.
Yes, sir. Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended, is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to, I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay, and you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant she could turn herself in. That was some amount of years ago?
It was before, definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overall, the witness has opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight?
As her attorney,
Okay.
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second. Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr. Descalzo.
Prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
Okay. And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
Just a moment, Your Honor. Defense would call Sarah Newhouse.
Sarah Newhouse. Okay. Yeah, the defense said 2 witnesses, and then the rest was supposed to be up in the air, which we can see is still up in the air. Joe Snowman said they got Donna the blue chair today. They did indeed. Interesting. And so court lurker said 1 more witness, then we find out if Donna will testify. I hope we'll find out today. Don't call it an early day and then say we'll tell you tomorrow, Judge, because that could happen too. Okay, they could be like, man. Not mayor. Sir, Judge Everett, Donna's tired now. Can we go home early and then she'll decide tomorrow if she'll testify? Oh, my word.
Please come up to the witness stand. Raise your right hand down. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendi Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendi Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendi Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendi Adelson called her mother?
It is.
Okay. When Wendi Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Okay. Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
At this point in time, I'd move into evidence Defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that, no objection.
A lot of qualifications.
Well, there's just...
Members of the jury, we're going to take a brief break. The bailiff will take it in the jury room.
Tick-tock, Donna. Almost time to make a decision.
You can be seated. If anyone needs to stretch their legs or use the restroom, please do it now.
Okay, so what I'm going to quickly show you, let's see. We're probably going to see it again, but I'll just quickly show you this. I'll monitor the court feed, don't worry. I think it's this moment here that they're talking about.
And so I know. Around the boys are fine. I had Lynn and Alan pick them up from school, and they're with Lynn and Alan right now. And I'm gonna leave here soon and go be with them. But I really need you to come here and be with me.
Oh, it was out of sync.
I need you to sit down. I'm fine, and the boys are fine. Danny has been. You can put me on speaker.
Okay, so I don't know why this law and crime upload is out of sync, but that's the call they're talking about. She just said to Donna, you can sit down. I need to tell you something. Danny's been shot, right?
Yeah. Danny has been shot.
What?
And I don't think he's gonna make it. And so I know. So I found this out around 1 or 2 today, and I'm at the police station, and I'm trying to help them figure out who may have done this. The boys are fine. I had Lynn and Alan pick them up from school, and they're with Lynn and Alan right now. And I'm gonna leave here soon and go be with them.
Okay, so you get the gist of it. That's from when they showed that at previous trials. So hold on one second. We're going to bring the court feedback up now that they're going to decide what to do with it. Are you ready?
I don't have a problem removing.
You said that once those things are removed, telling Ms. Adelson.
Okay, and we're back. Stefan liked the picture. This one.
It includes Wendi Adelson saying this is the worst day of my life before the call connects, and then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those 2 comments. I'm fine. I understand they don't tend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
And as I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can bring back in the jurors.
Fight for Dan says put the domestic coordinator on. Somebody also said it was Max Dirk. Nobody but Donna can decide about her testimony. My guess is her attorneys are opposed, but she wants to and will. Probably her. Thank you for your sticker. Fight for Dan. And Deborah McGee. Thank you so much. In my opinion, that part of that police interview, many others too, they felt very rehearsed. Okay, so right now, they bring the jury back in, and in the meantime, the defense has to edit out a comment before and a comment after.
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendi Adelson, her daughter, presumably does know.
Correct.
And do you remember Wendi Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the report.
Please sit down. As to the hearsay, sustain.
No further questions.
Redirect.
Your Honor, can we just strike the question from Ms. Kaplan?
Members of the jury, you are to disregard. The last question of the prosecutor is to be struck from the record. You may step down. Will the witness be recalled?
No, Your Honor.
It's crunch
To
time, Donna.
your exhibit, do you wish to publish or just leave in evidence?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the 2 references. That could just take a few minutes.
Well, the jury will have a brief break. The bailiff will take you to the jury room once again.
Back and forth today, hey? Donna, are you contemplating your decision? George is coming for you.
Everyone can be seated. Please make all necessary redactions and changes at this time.
Okay, so the jury is not present right now. Hey.
Mrs. Kappelman wants the defense rest. Is the state intending to place
Hey,
or
wait.
put on any...
Excuse me. We don't want to miss anything.
Can we just strike the question from Ms. Kappelman?
Okay, we got that.
The jury will have a brief break. The bailiff will take you to the jury room once again.
Let's just leave it at that. We're only 2 minutes behind the live feed and we don't want to miss a thing. So Donna's, just based on that little sneak preview we got, she's not taking the stand, right? Let's see. So the defense has to make a redaction on that clip of the Wendi Adelson police interview.
Everyone can be seated.
See, they go silent for a while, but now
Please
listen.
make all necessary redactions and changes at this time.
Okay, so the jury's out of the room. Come on, judge. Camera person, put the sound back on. Southern California says, hey, gee. I know, right? Dark, booming thunder said, jury, unhear that. It never works, though. Sound, please. See, we don't have sound now. But they do bring it back, don't worry. And we go up. It's just so we can be a fly on the wall. Oh, we're coming back down.
If there are no other witnesses for the defense, it is time for the decision to be made.
Oh yes, a time for a decision.
I can tell the court that co-counsel and my client are deep in conversation concerning this.
I am capable of seeing that, Mr. Zellman. No narration is needed.
No narration is needed. How dramatic. The time has come to make a decision. Well, as you can see, they're in deep conversation. The judge has given him so much time. He's like, mm-hmm.
Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
I think not. If they rest without calling any further witnesses, that could change.
See, I think the judge is reading the room. They're like, probably not going to testify. So after they rest, any rebuttal witnesses?
Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of it.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not.
Decide
I cannot
now.
make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorney.
This has already been discussed, ma'am. What is your choice?
So dramatic.
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
Oh my word,
If
Donna.
anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
This is too much. Donna thinks she's very, very special. This affects the rest of my life. Yeah. You don't say. You had a lot of time. Your defense attorneys indicated before the trial even started she wants to testify. What happened to all that? Oh, you got Kappelman, eh? You got scared. Saw the evidence mounting, read the jurors' faces. Damn it. I don't know if I can convince these people. I was glaring at them. I was putting on lipstick sometimes with a scrunchie. These people aren't giving in to my manipulation. Okay, sorry for the dramatic reenactment. And we're back.
Gentlemen, Ms. Fulford, Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion. We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these 2 rights?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Didn't say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
Ask for several moments, Georgia. No, I'm just kidding. She won't testify. At this time, she said she won't. She's too scared of Georgia Kappelman. And she thought that her pastel cardigans were going to work out really well. But she's not so sure anymore. She wants an outfit change. A fresh, hot shower. Maybe a pastry. And then she'll decide. Oh my. Now we're all caught up. So let's see what the local time is. 3:15, huh? Are we going to see closing arguments today? Or are they going to do this tomorrow? I don't know, but soon something's going to happen. We could have jury instructions. We could have closing arguments. Heck, we could be on verdict watch later. I'm so ready.
There is one matter, Judge, that I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors, or we can decide the language now if you find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists?
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. We'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Excellent.
Your Honor,
Can't wait.
Counsel, I have a moment to confer concerning whether or not we are going to rest at this point.
Do you have another witness to call?
That's what we need to discuss, Your Honor.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense.
You mean Charlie? Is it Charlie? Charlie takes a stand. Charlie's hanging out somewhere there in the back in jail. I'll be up there for my mom. I got LWOP. Let me get her LWOP too. We're so close. Ooh, this must be difficult for Donna not to have the last word, hey? And to control everything. Yeah, Donna, shame. She moistened her face. She brushed her teeth. And she was so ready to take the stand, but she's now not so sure. She's not sure about that thing called cross-examination. That seems scary. Oh, shame Harvey. Okay, Harvey looks like he's come to the realization that she might get LWOPed. Maybe he was rooting for her too. He looks like really, I don't know how to describe that look. Just like, oh man, like, okay, she's not testifying. He had high hopes for her getting on that stand. Fight for Dan says, Charlie. Maybe. I mean, that could be the only other option. Who else? It's Charlie. Good luck with that cross-examination. Fight for Dan, thank you for your sticker. Now, Charlie P456 says, you'll be able to get a nap in if they finish early before your court TV appearance. Sure, I was already thinking ahead, like, wait, if we're on verdict watch later and I'm on court TV, can I just, if the verdict comes in, I have to say, Vinny, I have to go. I'm so sorry, but I have to go because the verdict's in. Can you imagine? So luckily that won't happen today. I'll be on court TV. I'll have a nap after probably because I'll be way too excited to actually sleep before. And then tomorrow, jury instructions, closing arguments, verdict watch. Can't wait. Which means today they send the jury home early. Then they're going to do a charging conference. I don't know if the cameras will keep rolling for it or not. They usually do. So if they do, we'll watch that together. Louise McKenzie said, you are too funny, Grizzly. I love your acting. You crack me up. Oh, thank you so much. The snark comes naturally. Oh, man, especially with people like Donna.
Is there another witness to be called?
Your Honor, we are going to be tendering 2 exhibits to the court to introduce.
Flappity, flappity.
That both qualify under hearsay exceptions. The state's indicated that they're objecting. If I could just have a moment.
That doesn't have much to do with the witness, does it? Listen to the judge sigh. That's a good question. Wait, who asked that? Vanessa Tick said, what exactly was Donna's defense? Everybody try to summarize it in one line. What was Donna's defense? I don't know, that Wendi did not have a contentious divorce, and therefore acquit her now. Let her walk free. She's ready for her second attempt to go to Vietnam. Right? Stefan says exhibits. We're talking about another witness. And they're flapping around there. Shame, Donna. You waved the white flag, huh? You have surrendered. Colleen says they are trying to buy time to go home. But the jury's already going home. They are going home. They're just going to do a charging conference, though, the attorneys. Ah, these people. Police 123 CD, thank you for your $5 sticker. MG said her defense is she believed it was extortion. But we didn't see much of that. We didn't see a lot of that. She may have said that if she was going to take the stand. Here we go.
Mr. Zellman, concerning the items, we do need to move on so a ruling can be made.
It's like, Donna, if we put Charlie on the stand, then George is going to cross-examine him too. No, that can't happen. It can't be done again. Okay, yeah, I know, we rest. Is that how it's going to go? I'm speculating. I know you want to see your son one last time, but this is going to severely impact your case. Trying to talk some sense into her over there. Monica says, I think this judge is about to blow his top with all this nonsense. I think so. He's about to become a tank. He's been a lighthouse all along.
Your Honor, yesterday the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar as well as the 2023 calendar. That is, I believe it's States 51. No.
Sir, we're asking if there's going to be another witness, not if we can see Donna's diary. And you know what? Yeah, give the jury that entire diary. There might be more things in there that are quite interesting. Molly the G said, gee, I was watching you during my facial. My, I don't know how to say it, esthetician is now a follower. I do love that. Grizzly recruit. Donna reflecting on a decision. Judge, I want to change my mind. Do it, Donna. Change your mind now. You still have time.
Ms. Cobbleman, concerning these items, what is the state's argument?
The state's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar. It's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents, and the state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that,
why did you not object then?
There are a ton of pages going back to January 9th of 2023 where my client lists those very same items to get prices to sell, to sell, to sell. So it is misleading to just put in those.
Well, not really, because Charlie was already arrested in April 2022, and Donna was like, oh crap, sell everything.
A couple of pages that the state put in on the 2023 calendar for purposes.
Who was going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was seized
I
by.
believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but
it started when her son was arrested.
It happened previously, not for the truth of the matter asserted, not that she was.
Hold on, these are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. So these are just the pages with those entries.
As to that, I will reserve.
I mean, it doesn't sound like a witness. Is the diary a witness? Could the diary be put on the stand?
Whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research, but again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I'll reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just one.
Thank you, Police 123 CD, for being a member for 19 months. Like, I don't know, is there going to be another witness defense? You think that whole diary is going to make a difference? Look at the judge. Donna's like, I regret my decision.
The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband, and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you had already made?
The only entry from the 14 planner that was admitted, has been admitted so far in this trial, is the page that shows
The license plate number.
License plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate number, so I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. The 23 planner was identified as by a witness as being seized from the residence.
I will reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor, and for the record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
Defense is about arrest.
And Judge, the state has made I want to check the redactions on this video.
I believe this is just being admitted without being published, correct?
That's correct,
Yep.
Thank you.
Jurors are fine to come in.
All right, you're entering the courtroom.
Here we go. Defense, are you going to rest now, or is Donna going to suddenly change her mind? Rhetorical question, by the way. She can't now.
Everyone can be seated. Defense may call its next witness.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45, and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
Donna's looking at hobby. Okay, so both the state and the defense have rested, no rebuttal witnesses. Now they will do a charging conference and then
Everyone can be seated.
call it a day. Tomorrow, jury instructions.
Please open your copies of the jury instructions.
Tomorrow, jury instructions, closing arguments, and verdict watch. Oh, yes.
My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
No, Your Honor. No, sir.
3.2, Statement of the Charge. Any requests or changes?
Not from the state. Your Honor, the only request that I would make is that the name of my client and the names of the charges do not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note.
The defense wants stylistic changes, no all caps for the name of the defendant, of their client. Not for the charges, not for her name. Okay.
Moving on to 7.1, Introduction to Homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
As to the next paragraph concerning lesser includeds, is the defense asking for all Category 1 lesser includeds?
Dan Markel's dead. Shame. Will they watch any more trials? Will Dan Markel's family have to sit through more trials? For full justice to be served, will there be more arrests?
Confirming my recommendation being approved by our client, Your Honor. Your Honor, the defense would request the manslaughter lesser.
As to the second degree lesser, are you requesting that as well as Category 1?
With the although it's a Category 1 lesser, it still carries the same penalty. So we are not requesting second degree.
Is the state requesting second degree as a Category 1 lesser?
Yes, sir. Yes, sir. We'd be requesting all lessers.
Well, all Category 1 lessers will be given. Second paragraph will read in the introduction, first-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. I believe the indictment refers to the victim as Daniel Markel. Does either party have a preference?
To conform to the indictment, we would request his full name, Your Honor.
Acceptable to that.
If you find Daniel Markel was killed by Donna Adelson, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these.
So, Charlie will not be testifying at all, if that wasn't clear, at this trial. They transported him for nothing. In the end, just to mess with them. Not that that was the intention, but he won't be testifying.
Not entirely certain we have any evidence in the record that would support giving them, but as I departed requested.
Just a moment, Your Honor.
Couple Horse says, I think they're all complicit. Not one without the other could have known. All need to be charged and convicted, in my opinion. Now, by the way, the poll. I've got a poll up if you're watching live with me. Do you think there'll be more arrests? I am limited to 4 options. Of course, could there be any other arrests? Maybe people advising Donna to make a run for it to Vietnam? I don't know. But the options are, do you think there'll be more arrests? Option 1, yes, Harvey and Wendi. 33% have voted for that. Option 2, yes, just Wendi. 56% have voted for that. Yes, just Harvey, 1% voted for that. And 10% of you so far say no, no more arrests. So if you're watching live with me and you haven't yet voted, cast your vote now.
I would agree with the court's conclusion there, Your Honor.
Mr. Evans, Ms. Koppelman.
No objection removed.
Just the definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers. Final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser included crime. As to count 1, the state is only proceeding on the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed. The elements of first-degree premeditated murder. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
Just the stylistic issues that we raised previously.
Oh my word. Stylistic issues. Drusilu said a copy of Wendy's testimony has been requested. It has. Yes, Grizzly Cat sent that to me. Transcripts of Wendy's testimony were requested by, I think, the state? It's been very interesting to see the filings going on behind the scenes. So who knows what's going to happen next, if anything.
Instead of caps, they will be in upper lowercase. Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given. The question of premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation, that will be removed. All right, instruction 3.4. This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
Yes, sir.
Your Honor.
like seeing all your answers. Leah says, I think Harvey will visit Donna in
7.4,
prison.
second-degree murder.
And you say loyal until the end. Some say you think that Harvey will get remarried. I wonder if he won't, if this will like all be too painful for him and he'll pack up and leave and actually go somewhere. Japan, Vietnam. I know they like to travel a lot. Maybe there's somewhere he'd want to go and just be retired. I don't know. Who knows? But yeah, we don't know.
Introduction to homicide will be given. This portion of the instruction will be removed. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson.
Sorry, I just want to answer this one. How do I say your name? Spalanky. So to be honest, if they sent home the jury now anyway, they could have let Donna take the evening and think about the testimony. But the thing is, she's not special, you know? And you said, and she would have probably testified. Not sure why the judge rushed it. He didn't rush it. He gave them so much time. I mean, including pre-trial hearings. They had so much time to prepare. Her trial was already set for like a year ago, and then it was postponed. So, and if the judge said, okay, everybody go home, Donna, you sleep on it, that sets a very dangerous precedent. You cannot do that for every defendant. You cannot do that for any of them. The time came, the defense was about arrest. They just had to decide if Donna would testify or not, and that's it, right? And so the day moves forward only now because Donna's decided she will not testify. Then the defense rested, and now here we are. Otherwise, this would have gone on for another week. If she had decided to testify, it would have gone on for longer, obviously. Brianna Henry said, I'm an hour or so behind. The entire defense is just bad, in my opinion, not helping her at all. Yeah, we'll have to see what the jury decides.
Element 3, there was an unlawful killing of Daniel Markel by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. As to the definitions, I believe act is repeated. Is there any objection to this stating an act has been previously defined above?
I don't have a legal objection to that, Your Honor.
Mr. Evans?
No objection.
The second definition, an act is eminently dangerous to another and demonstrating a depraved mind, that must be given. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legally adequate provocation. That will be removed. The next lesser, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. As to element 2, which theory is the state proceeding on?
I'm just going to pause here. Word Sleuth says, if Donna would have spent as much time considering Dan's fate as she did her choice to testify or not, we might not be here today. That is so true, right?
Well, A and B will be split by an or. Donna Adelson intentionally committed an act or acts that caused the death of Daniel Markel, or Donna Adelson intentionally procured an act that caused the death of Daniel Markel. Right. Concerning the State versus Spencer italic, that will be removed.
And my understanding, Your Honor, is given the fact that the defense has not requested that instruction, has agreed there's no legal basis to give the instruction, there is a concession that the homicide of Daniel Markel was not excusable or justified.
Zellman, do you need to be heard concerning the concession that it's not excusable or justified?
Not in the facts of this case, Your Honor.
And defendant agrees.
While I'm listening with you, I'm making sure our stream for tomorrow is set up to reflect that it's going to be closing arguments.
With that concession.
Very well. Mrs. Adelson, do you understand what is being omitted from the jury instructions?
Just 1 second, Judge.
Go ahead.
Okay, Judge.
Mrs. Adelson, do you understand what is being omitted concerning whether this homicide was justifiable or excusable?
I do.
As to that concession, do you need anything else that you need to discuss with your attorneys?
Yes. She said yes.
What
Please
is it?
discuss it with them now.
Thank you.
Yes, could they maybe remove count 1? No, Donna, they can't. Can't wait for closing arguments tomorrow. So when the jury comes in at 8:45 for day 9 of the trial, there'll be jury instructions and closing arguments and verdict watch.
Ms. Adelson, you understand the concession that is being made as to justifiable and excusable homicide?
I understand that.
You are giving your consent to this?
I am.
Let's move on at this point. The paragraph that states every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard?
We concur, Your Honor.
In order to convict of manslaughter by act, that paragraph will be given. The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent. and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No.
No, Your Honor.
The definition of procure will be given, and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The two elements are static. As to the portion below that is italicized, or any of the italicized portions being requested.
Thanks for staying with me through this.
I believe as to the first paragraph where it says
it's not for everyone, the charging conference, but I'm glad we could still be together and watch this, right? It is for some, it isn't for some. I understand if you don't like it, but thank you to those of you who are staying to watch this. And then we will, after this, once they call it a day, teleport, redirect if your autoplay is turned on, right? There's a little toggle switch for autoplay on. If yours is turned on, you'll be automatically redirected after I play the outro to the next stream, which is the closing argument stream. If not, then you just click on the link that I share with you in the description, well, in the chat, while we play the outro. But we're not there yet. We're first listening to the charging conference.
Attempted homicide cases.
We're not measuring this for the completed offense.
Say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for
Correct.
the completed offenses.
I believe that instruction must be given for first-degree premeditated murder, and all references to attempts of any other sort will be removed. The state must prove the defendant intended that the killing of Daniel Markel occurred. As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder,
by the way, if you aren't going to stick around for the last bit of this, if you want to see more of me live later, I'll be on Court TV today, September 3rd of 2025 at 9 p.m. Eastern. In fact, I'll be on at 9:30 p.m. Eastern for 2 segments, half an hour, the last half an hour of the show, which I'm really looking forward to talking about this case, okay? So you go to courttv.com, the website, you click watch live, and that's where you'll see me. Not on YouTube. They will upload it to YouTube later, usually a few days later. And when it's uploaded to YouTube, I add it to our playlist that I've made for you called Media Appearances, in case you want to rewatch any of that. All right, welcome, Ellen.
it is not necessary for the state to prove the defendant intended the death of Daniel Markel.
Your Honor, I think under that, the manslaughter instruction, or manslaughter needs to be included.
Concerning whether an intent was necessary for manslaughter as well, Mr. Evans.
Yeah, you have to intend the act, but you don't have to intend to kill.
As to that inclusion within the principal instruction, does the defense wish to be heard?
Just a moment, Your Honor.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not inviting error?
That's fine.
And so you can contact me on that, Judge, and I'll let you know later this evening.
Yeah.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as a second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. All right. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those?
Are you asked?
For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. I excuse Andrew down the principles already connects with that. So I ask yes or no. There's no evidence that the defendant in this case actually possessed the firearm, so no, we're not requesting it.
It will be removed. .5 sub B, principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all things the person who was promised or received the money did if the state proved beyond a reasonable doubt. Then elements 1, 2, and 3 are to be given. As to the bracketed portion of element 3, the offense that the state is asking for to read in element 3, would this be first-degree murder?
I'm sorry, Your Honor. Can you say that again?
Element 3, the bracketed portion that says crime or attempt, the crime that the state is requesting, is that first-degree murder?
Yes, sir, but I don't believe that, I don't think it asserts crime. I think you just leave the crime was committed by another person.
So not a specific crime, just crime?
Yes, and I think that's why they have attempt.
Unless you want the offense to be named, I will leave it at crime.
I don't believe, this crime is the appropriate one given the standard instruction.
I'm going to look at the standard reading, Your Honor.
The question is, will Freddie the Fly return for closing arguments? Because Freddie was there for opening statements, right?
The other person that is referred to in the bracketed portion, or any specific names being sought, or just the other person?
Just the other person, Your Honor.
I would ask that the individuals, Sigfredo, Garcia, and Luis Rivera be named.
I believe within the indictment, the named co-conspirators are Charles Adelson, Katherine Magbanua, and or other persons.
For count 1, Your Honor, there's no one identified.
Mr. Evans.
You, for principal instruction.
3.5 sub B, element 3.
Yes, sir. What I'm saying, for principal instruction, you do not have to allege it in the indictment in order to be entitled to principal instruction.
Well, but we'll read the crime was committed by the other person. As to the persons who committed the crime, I believe the evidence in the record is clear. It can only be argued that Luis Rivera and Sigfredo Garcia were the actual trigger men, although who may have put them up to the act as a conspiracy. That is for the jury to determine. Any other matters that need to be addressed with 3.5 sub B?
Just doing away with the firearm part of it.
That will be omitted.
And Your Honor, there's something I wanted to address briefly on 3.5A.
Go ahead.
By my reading, this is the new instruction.
This is the straight from the Florida Supreme Court on the Florida Bar website instruction.
Well, we are making the affirmative election to use the current instruction rather than the instruction that existed in 2014, which my client would be entitled to request.
This is the current instruction.
I'm sorry, yes.
This is the current instruction.
Yes, we are making the affirmative request for this rather than the old instruction. I want to make that clear for the record.
Moving on to count 2, conspiracy to commit murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, the intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2, as to agreed, conspired, combined, or confederated, which are being requested by the state.
All 4.
In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson, Katherine Magbanua, and or other persons to cause the first-degree murder to be committed, either by them or one of them, or by some other person.
Your Honor, on that, I think I understand the way it is written, but in order to avoid confusion, because the and or would apply between the Charles Adelson and or Katherine Magbanua and or other persons. So I think it could be.
You're just requesting an and or between names.
Yes.
Defense wish to be heard.
Your Honor, I always have a heartburn when I see and or in a jury instruction.
Going back to the indictment, these are the individuals that are within the charging document.
Did he say heartburn? What did I just hear him say?
I understand that it's in the indictment. I think it leads to potential confusion with the jury. We would ask that and or not be included.
And if that's the case, then you could put simply or. So and or, my understanding of and or are, it can include, basically, if you put something or, I mean, this one, or this one, or this one, or this one. And so in this case, if it's Charles Adelson or Katherine Magbanua or other persons, that would be acceptable to the state.
I don't have a legal objection.
Conjunction?
Yes.
What's your function?
Yeah.
Very well, Charles Adelson or Katherine Magbanua or other persons.
Everybody's going home. Stefan says, is there a court clapper? Shauna,
It
thank
is
you for the
not
coffees.
necessary that the agreement conspiracy
Now, is Harvey still there or did he leave? Hand the
combination
camera. Please.
or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators.
The judge is guilty of court coughing.
And lastly, it is not necessary that the defendant do any act in furtherance of the offense conspired. As to the affirmative defense, I am not aware of any evidence in the record that would require this to be given. Does the defense have any argument?
But did Harvey go too? I want to see. I saw
We
everybody
there
go.
is no evidence of it.
It will be omitted. Count 3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Katherine Magbanua, and or other persons to commit first-degree murder. As to this, are the parties asking this to read with the same or that it does for conspiracy to commit?
Yes, sir.
Yes, Your Honor.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Katherine Magbanua or other persons to commit first-degree murder during the solicitation, and which are being requested by the state.
All 4.
During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Katherine Magbanua or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation. I think the only area...
Go ahead.
I think the only area principle doesn't apply is for conspiracy.
Do you wish for me to move then the 2 principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation to commit murder as has previously been defined. Or do we need to?
The folks?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that. That's not been requested in previous co-defendant trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the 2 instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
The concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter, whether it can be argued that someone is a principal and solicited.
Thank you.
For now, I will just move the 2 instructions to the end of the counts.
I think at the end of the counts, it just needs to be clearly stated that conspiracy, it does not apply to the conspiracy count. I think we're all in agreement on.
I can add it, but ultimately no instruction can be argued as to defense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor, and that might be a moot point depending on the research that I do later.
Now we'll just add at the bottom the principal theory. Or actually, this instruction does not apply to count 2. And I have to do that for both principal instructions. Moving on to intent as a standalone instruction. This is not a standard instruction, but comes from Standard Jury Instruction 13.1 burglary, which gives a definition of intent.
Donna's just looking down the whole time. I was thinking maybe she's writing a letter, but she doesn't even have her glasses on. So I don't know. Janine Doyle said, Grizzly, do you think the jury will be swayed due to Donna's age? I thought it before the trial, thought it's possible, but based on everything we saw, I don't think so. In my opinion, I don't think so.
This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
The intent instruction then will remain.
We would object, Your Honor.
What is the basis?
Basis is it's not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection and what we given. 3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
It's probably number 10 is the only one we're not, but is it 6, 7, 8, and 9?
Does the defense have any argument for the giving of number 10?
No, Your Honor, we agree.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony? Or a misdemeanor involving dishonesty?
Like, even if you think, right, if Donna's only convicted on, let's say, solicitation to commit murder or the conspiracy, whichever one, she is 75 years old. When I looked up what would be the sentence for, let's say, solicitation to commit first-degree murder, it's a minimum of 7 years and it's up to life in prison. So she's facing, even if we just base it on that, 7 up to life without parole. Can you imagine? And she's 75 years old.
Whether the state has met its burden of proof, that will remain. To the next set of give as applicables, law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony?
Yes, Your Honor.
What is the requested instruction?
I have it typed out for you. Would you like to
Yes.
provide a copy to the defense? Sorry about the typo in the title. And the stipulations. It's all on Mr. Evans.
Right, as to the requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
Just want
Harvey's still there.
I have an objection to the first one, but the second one we do.
What is the objection? Is the second?
Your Honor, it's based, witnesses' presence in the courtroom is based on our apparent misunderstanding of the discussion that we had at sidebar last week. As a result, we think that the first one is an accurate statement of law, but under the facts, the second one would be inappropriate.
Kappelman, what is your argument for the giving of the second?
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
Your Honor, it's just dawned on me where you're sticking the previous requested instruction that the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence as opposed to, because
You're asking for this then to be inserted into the 10, or what would be the 9 questions and make it 10?
yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe, disbelieve all or any expert testimony, and then was the witness present in the courtroom during the testimony of another witness or witnesses. Certainly it's hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now.
Somebody was asking earlier, do I think that Donna Adelson will speak at sentencing. Oh man, yes, that's where she'll have the last word. And she'll probably say the same crap that Charlie Adelson said. That's if she's convicted, of course. The jury will have to decide if convicted, okay? At sentencing, she might say that she still... What were the 10 words Charlie said? Your Honor? He just wants to say that he's innocent, basically. Right, okay, so oh man, what if she has the last word? These types do. We've seen that before too in trials.
All right. Going back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
Not from the defense, Your Honor.
Those will be admitted. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor.
Pause. Charlie Adelson at his sentencing said, I would just like to say that I maintain my innocence. Yeah, I think Donna's going to say that. If she's convicted, she's going to have the last word at sentencing, and she's probably going to say that. I would just like to say that I maintain my innocence. She'll be wearing a cardigan, won't she? No, she won't. If convicted, she'll be in her jail outfit.
Can we go back to the first bracketed language, please?
Which is being requested?
Claims to have helped the defendant commit a crime. I think that would apply to Ms. Magbanua and to Mr. Rivera.
State.
Stop here. So we're, for the record, as I understand it, the bracketed languages under accomplices and informants
who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
All right, yes, sir.
So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. There have been no children witnesses. The defendant has not testified. Witness talk to lawyer. Is either party requesting this?
Yes, Your Honor.
That is a given. And the given all cases, you may rely upon your own conclusion about the credibility of any witness. That will be given. Defendant not testifying. This will be given in full. And we'll just change the pronouns to all feminine. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement. This specifically goes to whether the statement was freely and voluntarily made. As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
There you go.
Rules for deliberation. Standard instruction, this will be given. Does either party wish to be heard?
No, sir.
There you are.
Cautionary instruction, does either party wish to be heard?
No, sir.
There you are.
Single defendant, multiple counts, does either party wish to be heard?
Okay, let's just pause there quickly. Court lurker said, I want to hear closings before voting. That's what I don't normally have a poll like I just put up before we hear the closings. However, while we're waiting, let's see where we're at. That's why I said, at this stage, what do you think the verdict will be? Not guilty on all counts, guilty on all counts, guilty for some, not guilty for others, or hung jury, meaning they can't reach a unanimous decision. So, vote now. 65% so far have said guilty on all counts. 3% say not guilty on all counts, which means 31% are saying guilty for some, not guilty for others. 2% are worried about a hung jury. We'll do this again after closing arguments.
3.12 verdict. Any objection or request?
No.
Moving on to the verdict form. Count 1, we the jury finds as follows as to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Option A, defendant is guilty of first-degree murder. Option B, defendant is guilty of the lesser-included offense of second-degree murder. Option C, the defendant is guilty of the lesser-included offense of manslaughter. Option D, the defendant is not guilty as to count 1. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option, since she has the presumption of innocence. We would also request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to first option. That is overruled. As to the options being in bold or not, does the state have a position at which is to raise?
The only thing I would suggest if we leave them in bold, it makes it clearer for the jury to differentiate between each of the counts, but I don't have any real strong feeling about see why they would be in bold.
So you are requesting for it to remain the same or to not be bold?
I request they remain the same simply because I think it makes it much clearer to the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count 2, we the jury finds as follows as the count 2 of the indictment, conspiracy to commit murder. Check only one letter choice as to this count.
What about all caps for?
I need to go get some water, okay? So I'll be right back.
For the guilty, not guilty words in count 1.
This is stylistic because ultimately this has no bearing on how they're evaluating the evidence, correct?
I think the same reason why I'm asking for the names of the charges to be in regular caps, not all caps, throughout the instructions. It's the same principle.
State, do you have a position?
Your Honor, I think it's, to me, and when it comes time to sign the verdict, we want it real clear which boxes they are checking. I think this makes it the most clear. That's the reason I think the all caps and the bold are appropriate. The only stylistic change I would suggest, and like count 1, probably need to move the degree murder that's up under it over to fully under subsection B, and manslaughter fully under subsection C, so it's not up under the check box. But other than that, I think throughout the verdict form we're going to be asking the same thing. Leave it as is because I think it makes it much clearer to the jury when they're looking at it. You know what you're checking.
As to the body of the instructions, I will grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. 2 options, guilty and not guilty for count 2. Same 2 options for count 3, guilty and not guilty.
Would suggest, Your Honor, for count 3 that you move it off page 16 to the top of page 17.
I've been making several edits, so my pages aren't the same, but it will flow to where it's not being broken up between pages.
Thank you, sir.
All right, closing argument 2.7. Any objection or request?
No, sir.
No, Your Honor.
How much time is each party anticipating for their closing argument?
2 hours, Your Honor.
We would say the same, Your Honor.
Very well. Both parties will have 2 hours to present their arguments. Ms. Kappelman, yours will be broken up based on what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2 hours.
Don't talk me too much.
Submitting the case to jury, just with the time, nothing else. Any objection or request?
No, sir.
The items that are going to be sent into the jury room, I believe we have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
Just the demonstratives, Judge, on the exhibits, I think.
A demonstrative is not admitted, so yes, I would agree. It does not go back into the jury room.
Ms. Dugan and I spoke earlier during the trial about going through especially 73 and 73 and make sure it complies with the court's ruling, so we'll do that before we're sent back.
All right, and I will just leave it then. Photographic discs, jump drives, reports, and document exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. And the final instruction, when we reach the end of the case, instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
No, Your Honor.
I believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. I believe the state has requested within 3.5A for manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. I believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically asked to count 3?
It's specific, principle applies to count 1. There's not disputing that in any way, shape, or form. I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
Right. Once I've made my edits, I will send through my assistant an updated copy of the instructions. I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow. We're in recess.
Wow. 2 hours each side for closing arguments. Excuse me. Is that it? Anything else? Surely. Nope. The sound is off, so that's it for the day. Donna, look at Donna. I was going to say she looks exhausted, and will she sleep well tonight? I don't think so. Sure, I can't believe how the judge had to tell her several times, it's time to make your decision now, Donna. Will you be testifying or not? If you missed it, she has decided not to testify, or she had already decided, right? And then the defense rested. And here we are. The charging conference just happened, and Yep, tomorrow, if you're watching live, tomorrow will be September 4th of 2025, and we will be watching jury instructions, closing arguments, both together, and then we will teleport to the verdict watch, isn't it? Pam, thank you so much for becoming a member. Thank you to everyone who became a YouTube member today. You could also check out, if you want to, check out Patreon, because that's only $1, and you get all the YouTube members replays on Patreon and other behind the scenes content that you don't see anywhere else. So, you know, so thank you so much for that as well, for the stickers, the support, liking. Hey, almost all of you, that's amazing. Almost all of you checked if your like button worked. If you are one of the people that hasn't checked yet, then please check now if your like button works. Are you ready to teleport to tomorrow? Let's quickly see what you voted on the poll. 63% think that Donna Adelson will be found guilty on all counts, and 30% think guilty for some, not guilty for others. 4% think not guilty on all counts, and 3% think there could be a hung jury. Thank you for voting on all the polls we had today when we were live. Of course, if you're watching the replay, there's no poll, right? Tracy, thank you for reminding everyone. I will be on Court TV. Remember, it's not on YouTube, it's on the website, courttv.com. Click watch live at 9:30 p.m. Eastern. And so I'll be awake. I'll be probably staying awake for that. Very excited to talk about this case. And then tomorrow, I'll see you for closing arguments. Can't wait. All right, everyone. Thank you so much. That was quite an eventful day, hey? See you over there. I'm going to put the link in the chat as well. So you can click on the link and go to tomorrow already, or you can wait to be redirected automatically if you have autoplay turned on. Leave me some comments as well after the live stream. Here's my questions for you. What do you think is going to happen to Harvey now? If Donna's convicted, what will happen? Do you think there'll be jail calls tonight between Harvey and Donna? And what about Charlie? Charlie was transported for no reason. That must, as much as I don't have empathy for him, sting, because his mother's right there, but he can't see her. You know? All right, everyone. See you tomorrow.